allegedly went out of his jurisdiction over the jurisdiction of another DPP in KZN. The second aspect of paragraph 156 is that he exercised or purported to exercise prosecutorial powers. I need to hear more from the witness on that. And I may just hasten to say, and correct me if I'm wrong, Advocate Mutlamanyani, with the witness, as to whether Advocate Chauke took the prosecutorial decision in relation to the Katomena matter. Of course, the third aspect of that essence relates to him having settled the affidavit of Advocate Jiba. I'm not sure to what extent that aspect is relevant to the issue of Boysen's, the Boysen's matter. You'll just give us clarity there. Now, from page 1, paragraph 156, let's go to the letter that Advocate Batoyi wrote to Advocate Chauke. Counsel, I'm giving you this context so that you can help us, because we are all here on a fact-finding mission. We need to get the context right. If you don't, we are going to lose the focus of why we are actually here. The letter, Advocate Batoyi, if you remember, is attached to your affidavit. That letter that you wrote to Advocate Chauke is a letter of 2021. It's at page, or rather is marked SB 5231. It's a letter by yourself, dated 13 May 2021.
Chairperson, I wasn't reminded that I'm still under oath. If I
beg your pardon. I beg your pardon.
I do acknowledge that.
Let me remind you, Madam, that you are still under oath.
Thank you, Chairperson.
Unfortunately, you have not spoken.
Thank you, Chairperson.
Remember, you are still under oath.
I do.
Thank you very much for that. That letter that you wrote to Advocate Chauke is marked SB 5231, attached to your affidavit. In that letter, you drew Advocate Chauke's attention to the decisions made by him. I'm interested to understand the decisions that he took or allegedly took in relation to the Boysen's matter. We will deal with them duly decisions at the later stage. But before we close this chapter on the Boysen's matter, we need to get the crux of the Boysen's matter very, very clearly and understand precisely what is it that is alleged to have been done by him unlawfully, as you say, Advocate Batoyi. It is the impugned decision that we need to understand the context thereof, at least for me to understand precisely why we are here. You will see on page 231 of that letter, you refer to 1.1
Sorry, Chairperson, which page?
It is that SB 5231, the letter. You have that letter. That letter seems to draw our attention to matters that concerned you, that culminated into the complaint to the president. You see, in 1.1, you refer to Annexure A. That annexure is the affidavit of Mr. Mlotra. It's marked SB5A235. It is also attached to your affidavit.
That is correct.
Now, Council, I'm going to pause there. I thought that this sequence may help us to unravel the facts that culminated to the complaint and why we are here. The next and final aspect that I think we should look at are the terms of reference, because it is this context that I've mentioned very briefly that seem to have culminated in the terms of reference. Madam Batoyi.
That's correct.
I will just briefly, Council, just raise few aspects in the terms of reference quickly, very briefly, so that when you lead the witness, she will help us understand those issues arising from the terms of reference. And might I say, Advocate Batoyi, although this is not a prosecutorial process, it seems to me that the terms of reference are akin to a charge or indictment in a criminal case. Is my understanding correct?
Chairperson, broadly I would agree, but it's not restricted to that, because I think the terms of reference say, I don't have it in front of me, but it's not limited to. That's my understanding.
Yes. Let's look at the term as they are, and I'm just juxtaposing the terms of reference with what we normally refer to the indictment in a criminal prosecution.
I understand.
Not that we are in that zone.
I understand, Chairperson.
Am I correct, though?
Yes, that is so.
So if the terms of reference gives us the essence of the charge, for the lack of a better word, I call it a charge, we should actually zoom into the charge itself, the terms of reference, so that we can unravel all the facts that we seem to establish. That will make us understand why we are here. So quickly, if you look at the terms of reference, I think they can borrow you a copy. Your junior advocate can assist you and give you the terms of reference, the copy of the terms of reference. Okay, my clerk is behind you. He's going to help you there. Yes, thank you very much.
Thank you.
Now, if you look at the terms of reference, and Advocate Mutlamanyane, please indulge me.
I have, Madam Chair, in my heart.
I'm raising these things because we're working together to unravel all the facts that are relevant to the issues before us. And I'm doing so briefly so that we can have a structured understanding of what the evidence is. Now, if you look at paragraph 3 of the terms of reference, 3.1 Maybe you can start reading from 3. It refers to the fitness of Advocate Chauke to hold office. And we are expected to inquire into his conduct. Now, 3.1 talks about his direct or indirect conduct regarding those two matters. The first is 3.1.1. It reads, the institution of the racketeering charges. I'm more interested in that concept, the institution of the racketeering charges, whether he, Advocate Chauke, instituted the racketeering charges, be it directly or indirectly. I would like to understand that. If you can clear that aspect for me. And then when you go to the sub-paragraphs, 3.1, it suggests that, or rather the allegations are that Advocate Chauke supported a decision to prosecute in the Katumena matter. The second one is that he recommended to Advocate Jiba that the certificate should be issued. It is that recommendation that we need to understand very clearly, at least for me, whether it constitutes an illegality or an unlawfulness. Because remember in paragraph 142 of your affidavit, you refer to the unlawfulness of his conduct. 3.1.1.3, it is alleged that Advocate Chauke sought to defend the institution of the racketeering charges in the review proceedings. I'm keen to understand the impropriety of that alleged conduct. And the next one, 3.1.1.4, is that he, Advocate Chauke, instituted an appeal against the judgment of Judge Govan. Also there, to clear my mind, I need to understand the unlawfulness of that aspect, or the alleged unlawfulness of that aspect. So I am mentioning these matters before we deal with the Mdluli matter, so that we can wrap up this chapter properly, to know where we come from and where we are going to. Otherwise, we're going to lose focus. I may not have captured everything. I will ask my sisters if they have any comment to add to what I've raised. If not, then you can proceed, Council, if that structure can help us, at least to understand the context of this very issue of the Boyson's matter. Thank you, Advocate. Maybe before you start, I hope that I've made myself clear, Advocate Batoi.
Yes, absolutely, Chairperson.
The concerns that I have, so far as we have gone, because it doesn't appear that we have really gone to the crux of the matter to understand the illegality or the unlawfulness of his conduct, if any. So somebody must explain to us so that we can understand the charges correctly, and also to understand the evidence or facts underpinning those charges. I thank you. Proceed, Council. You may proceed. Kate Halley. Good morning. Welcome. We got your apology.
Thank you very much. I did intend to advise you last week of my intention to appear before the court this morning. Unfortunately, it was unavoidable.
Your junior did extend your apology to us, and we understand.
Thank you, Madam Chair.
You may begin, sir.
Thank you, Madam Chair. We, in fact, are going to proceed to lead evidence that will deal with the terms of reference. And in so doing, Advocate Patohi will refer to Dr. Broughton's supplementary opinion and its accompanying documents. We will, in so doing, be doing cross-references to certain documents that are particularly important in order to unravel what exactly we are alleging that Advocate Chauke has done. At the beginning, Madam Chair and your fellow sisters, I will refer, before she gives testimony on particular aspects, to the terms of reference. And as and when we proceed, I will indicate yet again as to which paragraph in the terms of reference a particular aspect pertains to. In the course of her evidence, she will also, to some degree, refer back to what has already been on record without necessarily elongating on what has already been testified upon. And Advocate Patohi, go to page 66 of your affidavit, where, as Madam Chair has correctly pointed out, the essence of the allegations against Advocate Chauke are dealt with. Now, you will remember that we will deal with paragraph in the main 156 together with its subparagraphs. It has 4 subparagraphs. And to begin, let me refer you to LO4 bundle, specifically page 1011, Madam Chair and your sisters. LO01011. you there?
If you just pardon me.
L04 is the bundle. The page is LO 1011, which contains some exchanges of emails between Advocate Chauke and Advocate Cyril Molocho. Are you there, Advocate Patohi?
I am.
Let us go to LO4 on page LO 01012. In other words, 1012. Are you there?
I am.
There is an email which has been sent to Cyril Molocho. Do you see that?
I do.
Can you explain the email?
Yes, I can. So, Chairperson, perhaps to place this into context so that the panel understands how this came before me. Very briefly, I had obtained opinions of Advocate Nalane initially, and it is referred to in my affidavit under the process leading up to the referral. And then that was sent to Advocate Chauke. He obtained the opinion of Advocate Maineche. And thereafter, because of certain gaps that were identified, I asked Dr. Broughton, who is a legal advisor in my office, to look into the matter and look at all of the evidence so that the gaps are then addressed and provide me with an opinion. Did so, and his supplementary, he gave me two opinions. The first one, I don't have the, I thought I would be led on this so that we could get the context in, but it's the first supplementary opinion and the second one. They are referred to in my bundle. Chairperson, what I'm going to refer to now was in fact the evidence that he provided to me when he provided his supplementary opinion to me, and then attached a whole lot of annexures that support or the evidence with regard to the opinion that he provided. So I think it's important for the panel to understand the context of how this came before me so that I can explain in sequence.
When you say he, you are referring to Dr. Broughton.
That is correct. And perhaps the evidence leader will give you the, at some point, his the reference to his opinion, which is in the bundle, together with all the annexures. And this is forms part of that bundle, Chairperson. I may then proceed to answer the question.
You may proceed, ma'am.
Thank you, Chair. Chair, so this, what we're referring to now, at page 112, for clarity, Chairperson, the email chain starts from page 112 and then continues backwards to 1011. So you read from 112 to 111 for clarity, Chairperson. So the first email is 12th of June 2012, sent from Mamiki Suping who is the personal assistant of Advocate Chauke. And the evidence will show that the subject line is indictment, Cato Manor, that certain documents were sent to Cyril Malochwa. Now, Cyril Malochwa, Advocate Malochwa, at the time was the acting
I
DPP.
think that's better. I think we can refer to him as Advocate Mlojo.
Sure, thank you,
I
Chair.
heard Advocate Msamunyane referring him to Cyril, and I didn't know who is the Cyril. So it has helped us.
My apologies.
Let's address people properly.
Chairperson, Advocate Malochwa was at the time the acting DPP in KwaZulu-Natal. So Advocate Chauke's PA forwards to him certain documents. Thereafter, you have if you turn over to page 1011, at the bottom, the second email in that chain is one from Advocate Malochwa to Advocate Chauke. And he states the following: Dear Advocate Chauke, our telephonic conversation today refers. Kindly furnish me with the prosecutor's memo or report so that I can have a wraparound view of the matter. The report must also have the police stations and CAS numbers so that we can open the DPP's file. Thank you in advance. From that, it appears that at some point before this email was sent, there was a telephonic conversation between Advocate Malochwa and Advocate Chauke. And my understanding from the evidence leader is that Advocate Malochwa will in likelihood be called. Chairperson, in response to that email, we go still on 111, LO 1011. Advocate Chauke responds on the same day to Advocate Malochwa and states, I'm not sure that I need to read the entire document, but perhaps I will read a few parts from it. But if the panel wishes the entire document, I'm happy to do that. Dear Advocate Malochwa, who is the prosecutor that you are referring to? I have forwarded you the indictment, which has all the detailed summary by which you ought to be in a position to open your file. I also forwarded to you details of the inquest with the police CAS numbers to which you referred to Advocate Toko Majokweni for reasons that I do not follow and understand. The indictment with respects gives you the whole view of the matter. And I emphasize that the indictment with respect gives you the whole view of the matter. He then goes on to say, you are kindly and fervently requested to please discuss any issues, if any, with me. I really do not see any need for me to give you any report other than that which I have forwarded to you already. And this is important as well. It should become clear. Please, if I misunderstand you, make me understand. I do not want to play you or undermine your jurisdictional authority in any way whatsoever. It then proceeds, Chairperson, he then on the next paragraph says, I've also learned with utter dismay that you have now issued an instruction to senior prosecutors that all dockets that are with us must be brought to you. What is not happening here, my brother? Please, if you have any issue again, talk to me or arrange that we see the acting national director urgently, and that would be Advocate Jiba. And he then goes on to raise a concern. He states, another concern to me is the delay in you issuing the instruction of reopening the inquest in view of the fact that you have been requested to sign the indictment, which must be preceded by your decision to reopen the inquest. If this makes you uncomfortable, please indicate so I may urgently take the matter up with the acting NDPP as well as the minister. And I emphasize that as well, for reasons that will become clear later. I do not want to step on your toes in the last paragraph. I was informed that you agreed and arranged with the acting NDPP for someone from outside to do the prosecution of these matters. If you now have a change of heart, please indicate so that we may resolve it as soon as possible. That is the end of the letter.
Now, Advocate Batohi, we will later refer to these exchanges here. But for now, go to paragraph 60 in bundle LO1 on page
60
Sorry,
or 16?
sorry, Advocate.
I beg your pardon.
Before Advocate Batohi steps off this letter, she read the letter, but at paragraph 2, she skipped a line, and I'm not sure whether it's not supposed to be in the record, but I think it is important when we quote someone, we quote the whole thing, unless if we feel it is not important. In paragraph 2, line 3, the sentence that starts with "there are."
If I may, Chairperson, yes, I had not intended to read the whole thing, but perhaps and I went on and read most of it. So perhaps I will just add paragraph 2, the last sentence, or third line. There are serious issues of security in this matter, which if necessary you will be briefed about, which are not relevant to you, and I cannot expose you to such at this stage. I think I read the rest of the letter completely, except for that. Thank you, panel.
Thank you, Councillor.
Thank you, Madam Baloimere. Advocate Batohi, go to LO1 on page LO00266. Two 00266. Therein, you will find
266.
yes, 266 is a witness statement of Advocate Andrew Chaoke, which was before the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public service, including organs of state, colloquially known as State Capture Commission. It starts on page 243. Do you see that?
Yes.
Go to paragraph 60 and read it into the record. 60, Madam Chair.
Yes, thank you.
So, if I may proceed, Madam Chair.
Yes, you may proceed.
Proceed.
Paragraph 60 states as follows. Jiba requested me to assist with putting together a prosecution team which will guide members of the police and members of IPID, open brackets, in quotation marks, the Cato Manor team, close quote, close brackets, on the investigation and prosecution of the matters. I agreed to be the coordinator of the prosecution team. The prosecution team was comprised of the following advocates: 60.1 Advocate Maema, DDPP, in brackets team leader, in brackets Maema, Advocate KR Matenjwa, DDPP, co-team leader, Matenjwa, Senior State Advocate M. Ntlakaza in brackets, Senior State Advocate J. Molochwa in brackets, and Senior State Advocate F. Fuchane in brackets, and Senior State Advocate P. Moleko in brackets.
We know that Jiba is reference to the then acting director of public prosecutions.
Acting National Director.
Acting National.
of Prosecution.
Yes. Is that correct?
That is correct.
Now, go to the next page, which is
What is the relevance of this paragraph 60? Before we forget about it.
the relevance of paragraph 60, Madam Chair, has to do with the request that the acting National Director of Public Prosecutions made to Advocate Chauke to put up a team together that will go to KZN to deal with the Katomana incident.
Now, when you go back to the terms of reference, 3.1, does this aspect have any relevance
This,
to, I beg your pardon, let me finish. Does it have any relevance to the opening words in 3.1 of the terms of reference that Advocate Chauke, directly or indirectly, by his conduct, instituted the racketeering charges? I mentioned that, Council, and please allow me to keep on going back and forth on the terms of reference because we refer to the evidence without linking some of these allegations to the terms of reference. So if you can help me to understand the relevance of that paragraph in relation to the terms of reference themselves.
Thank you, Madam Chair. It is my omission. Let me hasten to say paragraphs 3.1, 3.1.1, 3.1.1.1, 3.1.1.2, 3.1.1.3, and 3.1.1.4 for now are relevant not only to this paragraph 60 and 62, but are relevant to the evidence that will indicate Advocate Chauke's involvement in the prosecution of the Katomana police officers.
Would you like the witness to confirm what you are saying? Because it is her who must place that evidence before us.
Indeed, Madam Chair.
Do you confirm that Advocate Batoi, what your Advocate Mohlamayane has just placed before us?
Yes, Chairperson, if I may explain as well that all the evidence has to be seen together because they explain what happened over a period of time and gives the full picture of what happened. So the evidence leaders started with the setting up of the team, and they will all speak to, I confirm, what is mentioned in paragraph 3, right in fact to 3.1.1.5, which is on page 7 of the terms of reference. So
Yes, Councillor, I think let's just try to take it one step at a time, because what you are now saying is the broader picture, but you are addressing the essential terms of or rather the chapters of the terms of reference. But if you give such a broad overview, we will get lost. And if you can try to answer a pertinent question so that you don't give a long answer that takes us back and then we lose the focus. What I wanted you to confirm, so that it is not counsel who is kind of testing from the bar, then you say it yourself, because it is your affidavit that we are concerned with here. And what I wanted clarity from you is whether, in relation to the question that I posed to counsel, the very, very sub-paragraph of the terms of reference that seems to suggest that Advocate Chauke misbehaved. And I would like us to understand the context relevant to that allegation in the terms of reference. And that's what he was saying to us, that all those paragraphs in the terms of reference, 3.1.1 to 3.1.4, are relevant, and paragraph 60 supports those allegations in the terms of reference. And I wanted to ascertain with you whether you confirm that. Perhaps, Counsel,
me look at whether-
you can just repeat to Advocate Batoi what you were saying in a simple way, the way you want to put it to her, so that we get this part of her evidence clearly.
Thank you, Madam Chair. Advocate Patohe, if I take you back to paragraph 60 on this page here, page 266, would you confirm that what is stated there is pertinent to paragraph 3.1?
That is correct.
It's also pertinent to paragraph 3.1.1.1.
Well, Chairperson, I'm a little confused because paragraph 60 deals with the team that was set up. And if we look at the particular subparagraphs of 3.1, they relate to different aspects of Advocate Chauke's conduct. And so I'm a little confused about answering the question that paragraph 60, which simply deals with the team setup, how it links to each one of the subparagraphs that describe Advocate Chauke's conduct.
You remember, through you, Advocate Mutlamuyani, we zoomed into the terms of reference, 3.1. That talks about Advocate Chauke's direct or indirect conduct. And your Advocate Mutlamuyani took us to paragraph 60. That speaks to the role played by Advocate Chauke, if I may put it that way.
That's correct.
That is how that speaks of to get the factual metrics
correctly pointed out, it has to be read with the total. With its sub-paragraphs into the record.
Paragraph 62 reads as follows. My role as team coordinator was 62.1, deal with the logistics and administrative matters of the prosecution team. 62.2, ensuring coordination between the various stakeholders. 62.3, my involvement excluded taking prosecutorial decision whether to prosecute or not. 62.4, feedback and briefing on the team to JIBA, including the submission of documentation from the prosecution team. Chairperson, if I may at this point explain that paragraph 62.3 refers to taking prosecutorial decision whether to prosecute or not. My evidence will include the fact that a prosecutorial decision is not one that is limited on whether to prosecute or not, but there are various prosecutorial decisions that are taken in the course of a prosecution process.
Well, probably it's a matter of argument, but thank you for telling us what you are telling us.
Thank you, Chair.
But we do know from that paragraph 62, sub 3, Advocate Chauke is saying, I was involved, but my involvement excluded taking any prosecutorial decision.
That is correct, Chairperson.
That's the nub of his statement.
That is correct, Chairperson.
You may then proceed to paragraph 64 on the same page and read it into the record.
I beg your pardon, Counsel. I beg your pardon. I beg your pardon. And please correct me if I am missing something. That very aspect at paragraph 62.3 will probably take us to the statement or affidavit of Advocate Musing.
It will.
It will.
It will, Madam Chair, as and when we proceed.
Thank you. Please flag it so that we don't forget.
Yes, I will do so. If you may, Advocate Batohi, read into the record paragraph 64, and I will later refer you to paragraph 60, 95 and 96. But for the moment, read paragraph 64 into the record.
Paragraph 64 reads as follows. On 3rd May 2012, I attended a briefing with JIBA, during which it was arranged that the prosecution team brief her on the Cater matter on 18 May 2012. On 15 May 2012, I attended a meeting with the prosecution team to prepare for JIBA's briefing.
We are still on Advocate Chauke's affidavit that's served before the State Capture Commission, and go to page 273, LO 273, in this bundle LO1. Read paragraph 95, which ties to the one, which paragraph 60, which you read earlier?
Paragraph 95.
Paragraph 95, Madam Chair.
Paragraph 95 reads, I have read the affidavit by Advocate C.S. Mlochwa dated 23 July 2015 under Silverton CAS, which is annexed to the Rule 3.3 notice. I refer to what is set out above with regard to how I came about to be involved in this matter as a coordinator of the prosecution team, and that the latter was giving briefing to the Advocate C.S. Mlochwa about the matters.
Will you confirm that this paragraph pertains to paragraph 3.1 of the TOR, terms of reference?
Yes.
Proceed to go to paragraph 96 on the same page and read it into the record.
I confirm that I had the email exchanges with Advocate C.S. Mlochwa. The issue was sorted out between me and him. I considered it resolved and did not take it any further. I held the view then, and even now, that he was sufficiently briefed by the prosecution team about the matters. I realized the omission of the memo, which I thought was part of the draft indictment, for which I apologized. This is borne out of the fact that he indeed received the memo and the indictment. I even indicated above with him and attended meetings with him and the AJP on 18 June 2012 and the court appearances by the suspects.
Now, Advocate Chauke mentions Advocate C.S. Mlochwa. I want us to hasten to get to Advocate Mlochwa's affidavit that you referred to and Madam Chair has also referred to it, which is attached to your letter to Advocate Chauke, which is marked SB6 on page 240 of your bundle, where you were making a request for further information relating to decision made by you as the DPP Gauteng, Johannesburg. Now go to...
Pardon again, Council. You said SB6. Is it not SB5A? That is the sworn affidavit by Advocate Mlochwa attached to her affidavit.
Yes, I was still on SB6, Madam Chair, which is Advocate Patohi's letter.
Where is the letter?
It's
SB6?
It's SB6 240.
240.
Yes.
I'm sorry for that, let's just get to that.
That's Advocate Chauke's
No, it's
letter to me.
yeah, my mistake. It's SB5 actually. Yeah, it's SB5, Madam Chair. I made a mistake. I apologize for that.
SB6.
SB5. SB6 is Advocate Chauke's response.
Yes, I thought that you are now addressing or asking Advocate Batoyi to deal with that affidavit of Advocate Mlochwa.
Indeed, Madam Chair.
Which is SB5A
in 236. That is so.
Yes.
Go to SB5A 236.
Yes, I'm there.
On top there, it's written Silverton CAS. It's not clear as to what number it is there, but it's of 10. Looks like it's 2014.
That's correct.
explain this case, Silverton case. What was it all about? Why did he depose to an affidavit in this matter, Advocate Mlocho?
So CAS numbers are granted when a docket is open in a police station. And so the CAS number, the police station would be reflected initially, and that is Silverton. In this case, it's Silverton Police Station. And then CAS is the CAS number. It's unclear what the number is, but the second number reflects the month, and the third number reflects the year with relation to a criminal docket that would have been open.
The affidavit that Advocate Chauke refers to in paragraph 95 of his affidavit on page 273, which you earlier referred to, affidavit of C.S. Mlocho. This is the same affidavit that we are now looking at, SB 5A.
I'm not sure. Where's the other document? I need to check to see it's the same document. Or are you telling me it's the same document? I apologize, Chairperson.
If I may, Council, remember SB 5, which I mentioned, is mentioned for the first time in the affidavit of Advocate Batoi under the rubric of process leading to the referral to the President on page 69 of her affidavit. But of course, that SB 5 addresses also the issues relating to the Boyson's matter. In other words, it refers to the broader issues of both the Boyson's matter and the Mdluli matter. So if you can probably look at it, it is there, Council. SB 5 is mentioned for the first time at paragraph 161.
That is correct, Chairperson.
Now, Advocate Chauke says, Advocate C.S. Mlocho's affidavit is dated 23 July 2015. And this one is dated 12 May 2015. It is not the one that he's referring to, not so. Do you see on page 237, the date when it was deposed to is 12 May 2015.
Yes, I see that.
Now, it is not the one that he's referring to because this one is dated 12 May 2015, not so.
Sorry, I'm confused. Which is the one he's referring to?
I'll take you to the one that he refers to. It's on the next page. He says it is dated 23 July 2015. Go to the next page and look at 238. Page 238.
Yes,
There's another affidavit there by Advocate Mlocho. Do you see that?
Yes, that's correct.
Which is dated the 23rd July 2015.
That is correct. I see that.
So that is the one that he's referring to.
Sorry, I'm confused, Chairperson. I'm not sure who's referring to which statement.
Let me take you back to 95.
Page 95 or paragraph 95?
Paragraph 95
of
LO1, which is the affidavit of Advocate Chauke, in which he says he has read the affidavit of C.S. Mlocho, dated 23 July 2015.
I'm with you.
Yes. Now, I'm saying to you, this one on page 238 is another affidavit deposed to by Advocate Mlocho. You
That's
see
correct.
that, dated 23 July 2015.
Yes, that's correct.
Now, can you read it into the record?
Which one?
The one on page 238.
I, Cyril Simpiwe Malachwa, hereby state in English that on 23rd July 2015, the investigating officer, Major General Chalo, requested me to hand over the emails referred to in my statement dated 12 May 2016. Emails herewith. That's the content, and then it's the oath after that. He'd signed, and there's the oath.
If you go back to the previous affidavit, you will see that the paragraph on page 27, which is the last paragraph of Advocate Molochwa's affidavit,
I beg your pardon? Paragraph?
it's not marked. It's not marked or given numbered rather. It's not numbered, but it's the only paragraph before the commissioning, before the.
Is that the one with handwritten 491?
Yes, Madam Chair, with the old bolded number 156. Do you see that one?
In the bolded number?
156. But the correct number, the paginated number is 237. SB5A 237.
Council, you are taking us all over the show. Where are you?
I want the witness to confirm the issue of emails and tie it with the exchange of emails between Advocate Molochwa and Advocate Chauke.
Are you finished? Are you done with SB 5A 236? That's the affidavit of Advocate Mlocha. I thought that you were there.
I am there, Madam Chair, because it goes to the second page. Yes, it goes to the second page, 237.
Yes.
Now, Advocate Molochwa in this paragraph says, I thereafter exchanged a number of emails with Advocate Chauke, copying in Advocate Jiva, her personal assistant, and Advocate Majokweni, requesting Advocate Chauke to give me the prosecutor's memo or report as per initial agreement.
Which paragraph are you at?
237, where the affidavit of Advocate Molochwa ends,
Yes, I'm
where
there.
he has deposed, where it is commissioned.
Yes, I'm there.
Now, he says on 12 June 2012, Advocate Chauke's personal assistant, Ms. Mamiki Suping, emailed me only the indictment without the prosecutor's memo or report. Can you read that into the record?
On 12 June 2012, Advocate Chauke's personal assistant, Ms. Mamiki Suping, emailed me only the indictment without the prosecutor's memo or report. I thereafter exchanged a number of emails with Advocate Chauke, copying in Advocate Jiba, her personal assistant, and Advocate Toko Majakweni, requesting Advocate Chauke to give me the prosecutor's memo or report as per the initial agreement. My acting appointment came to an end on 9 July 2012. I never had anything to do with the matter after 9 July 2012.
Now, this ties with the exchange of emails you referred to earlier
That's correct?
in LO4, page LO 1011.
Do you want me to go back there?
You don't
No,
have to.
that is
I just
correct.
wanted you to confirm whether it ties with that.
That is correct.
Thank you. Now, Go to SB6.
And if I may, this aspect that you are asking the witness to read into the record has a direct link to the terms of reference. If I'm correct, which one?
Madam Chair, it has a direct link with paragraph 3, paragraph 3.1. Yes, paragraph 3 and 3.1.
The institution of the racketeering charges.
It will, yes, indeed. It will,
I beg your pardon.
No,
I
no,
beg
not
your
that.
pardon. His direct or indirect conduct.
Indeed, Madam Chair.
Please give me a second. If you may unpack that aspect for me to understand clearly this alleged direct or indirect conduct, how and to what extent it impacts on the prosecutorial role of Mr. Mlojo, Advocate Mlojo.
Mlojo, Advocate Chauke, Madam Chair.
Advocate Mlojo. The indirect, the direct, or the alleged direct or indirect conduct of Advocate Chauke's conduct, how it impacts on NDPP Advocate Mlojo's jurisdiction or space.
It will become clearer as and when we proceed to lead evidence, Madam Chair. However, for now, Advocate Mlojo was the acting DPP in KZN.
No, I understand.
Yes.
You are busy leading evidence. And this evidence is really the crux of the case because Advocate Batoi is laying the foundation of why we are here. And we need to understand this foundation correctly. Because other witnesses, as you referred to Advocate Mlojo, are going to either confirm their affidavit, the contents of their affidavit, or the evidence of Advocate Batoi. So I don't want us to have that disjuncture. We may just lose the connection. That is why I keep on taking you back to the terms of reference so that we understand the relevance of this evidence to the terms of reference themselves. I don't know whether it helps you, Counsel, but we get confused because we keep on referring us to bundles or legal opinions, and we just need to get it right to understand how you link this evidence to the terms of reference. And I thought that as we address this evidence, as we go along, you'll keep us on telling us that this is the aspect that is relevant to the charge at paragraphs 3.1, 3.1.1, etc. It will help me to understand the evidence of Advocate Batoy. I don't want to derail your line of the train of thought, Counsel, but if you may also help me. I am told that this is a tea break. If you feel that I'm overbearing on you, it's fine. We will get clarity at the later stage. Maybe you can proceed when you reconvene, and I'll note all these questions on the side so that I don't interrupt you.
No, you're not overbearing. You're perfectly entitled to the clarification, Madam Chair. I thought I had made it clear that the evidence that she's leading pertains to 3.1, but I'll take it a piece for a better understanding and for the comfort of everyone.
Yes.
Yes, I'll try and take it a piece.
Thank you, Counsel. Thank you, Counsel. We will take Advocate Batoy. We take a tea adjournment. It's already closer to 11:30. We will adjourn now and reconvene at 11:45.
Thank you, Madam Chair.
Thank you. We adjourn for tea. Advocate Batoe, remember you are still under oath.
I do. Thank you, Chair.
Advocate Mutlamiyane, please allow me just to cut to the chase. To go straight to the point in relation to that aspect that we're talking about so that we make progress. The evidence before us on record, and correct me if I am wrong, in relation to the affidavit of Advocate Mlocho, is that Advocate Chauke had asked him to sign the indictment. Am I correct?
You're correct, Madam Chair.
Let me confirm with the witness.
That is correct, Chairperson.
Advocate Mlocho, as I understand the affidavit or the evidence on this record, in this record, is that he did not want to sign the indictment because he had not been provided with the memo and the dockets.
Precisely, Chairperson. Or a report, as he indicates.
Yes. That begs the question, does that impact on the terms of reference in relation to Advocate Chauke's direct or indirect, alleged indirect conduct?
Chairperson, if we go to the terms of reference, this aspect of the evidence will relate specifically to Chairperson, let me, if I may, explain something. I know I've been asked to keep it short, and I really do, but I want to try to help I want the panel to understand the circumstances. So these terms of reference were drawn up. It appears that it was taken primarily from my letter that I sent to the President recommending an inquiry be held. The terms of reference were not discussed with the NPA, but it was taken from there. At that time, I must say that I didn't expect that those would become, in fact, the terms of reference. So I find it difficult sometimes to link specific aspects to it because, as I said earlier, this is events that took place over a period. And what we will demonstrate when all of the evidence is led is that Advocate Chauke's conduct related definitely addresses the 3.1 issues in 3.1 of the terms of reference. So your short answer, Chairperson, is that it will affect the supporting a decision to prosecute the accused 3.1.1, 3.1.2 in particular. And if one looks at my affidavit, it will particularly relate to, if I can be referred to the essence of the case against Advocate Chauke. If there's one aspect that's mentioned there, if one looks at paragraph 66, page 66, paragraph 156, it would relate specifically to 1563, he undermined or attempted to undermine the authority of the acting DPP KZN.
Thank you, Advocate Batoe.
Thank you, Chairperson.
It helps.
Thank you, Chairperson. And if I may explain to the panel how racketeering certificates are authorized. With regard to racketeering charges, the National Director of Public Prosecutions is required to authorize these charges. And what happens in terms of the process is that the DPP of the division where the charges emanate would submit a memorandum, a covering memorandum, generally with a with the indictment, with the prosecutor's memo, and any other relevant documents to the national director for consideration of the application for racketeering charges to be authorized. So in this case, what will emerge from the evidence, Chairperson, is that, as you correctly stated, Advocate Chauke and Advocate Molochwa will testify to this, is asking Advocate Molochwa to sign the indictment, and Advocate Molochwa is resisting, saying that I will not sign it unless I have these other documents. And he's correct in that regard, because he needs the evidence. The indictment sets out the charges and summary of facts. The prosecution memo generally will set out the evidence that actually supports the indictment. Thank you, Chairperson. I hope that helps.
It helps, Advocate. That settles my mind.
Then proceed, Madam Chair.
Proceed, sir. You may proceed.
Thank you, Madam Chair. Let me refer you to, before we revert to SB6, because we'll revert to SB6 at a later stage. Let me refer you to LO1, bundle LO1, LO00178. It is Dr. Broughton's supplementary opinion. And I direct your attention to paragraph 26.
Document in front of me. Is it SB3 you're referring to, 00178? Am I in a different?
LO1.
Oh, okay.
I'm referring you to LO1,
Sure.
Advocate Batohi.
Okay.
You got it in front of
Page
you.
number?
LO00178.
Yes.
Where Dr. Broughton deals with, and he has a subheading there, a subtopic, which reads, above paragraph 25, it reads as follows: Advocate Chauke's prima facie involvement in taking prosecutorial decisions to prosecute poison. And I must mention that this has to do, and I want you to confirm, it has to do with paragraph 3.1.1 of the TOR, the terms of reference.
That's correct.
May proceed to read into the record paragraph 25.
Paragraph 25 reads, besides endeavoring to compel Advocate Molochwa to sign the Boyson indictment without furnishing him with the case dockets or prosecutor's memorandum, in brackets, or supporting documentation and evidence, which aspect are returned to below, there is evidence that prima facie shows that Advocate Chauke was involved in taking prosecutorial decisions to prosecute Boyson. That's paragraph 25.
Now, I'm going to ask you a specific question about an indictment. For a trained lawyer, we know what an indictment is. For the public out there, can you explain what an indictment is?
Indictment is a document that is used generally in the High Court that sets out the charges against an accused person and generally also has attached to it a summary of the substantial facts relating to the charges.
Thank you. Proceed to paragraph 26.
Paragraph 26, it should be recalled that it was on 12 June 2012 that Advocate Molochwa refused to sign the Boyson indictment sent to him by email by Advocate Chauke without seeing the supporting documentation and evidence. The supporting documentation and evidence were never presented to Advocate Molochwa, even though the latter requested same from Advocate Chauke. The prosecution team also did not report to Advocate Molochwa, but to Advocate Chauke, and did not furnish Advocate Molochwa with supporting documentation and evidence for the signing of the indictment, which he, as the acting DPP of KZN, or a Deputy Director of Public Prosecutions, DDPP, in his office, or a DDPP acting under his control or supervision and direction of the KZN DPP, contemplated in Section 24(9), read with Section 21(3) and 4 of the NPA, was lawfully required to sign. As a result, Advocate Molochwa never signed the indictment. Indeed, after the exchange between Advocate Molochwa and Advocate Chauke in June 2012 regarding the signing of the indictment, and the request from Advocate Chauke to Advocate Molochwa to consider reopening a series of inquests relating to the matter, he heard no more about the Boyson prosecution. And Chairperson, if I may say, that to ask Advocate Molochwa to sign the indictment in these circumstances would in fact be unlawful. And the exchange, the email exchange that we referred to earlier, we referred to 2 emails, but it's important that the other emails are also considered because it shows the response of Advocate Molochwa and what the impact was of what he considered to be an unlawful instruction that he was receiving from Advocate Chauke to sign the indictment without the evidence. And the importance of this, Chairperson, is that when you put your signature to an indictment as a DPP or as any prosecutor, it means you are satisfying yourself that there is evidence that supports the charges in the indictment. And to require someone to do it without the evidence is in fact asking that person to do something unlawful.
If I may refer you back to the emails, exchange of emails between Advocate Chauke and Advocate Molochwa. LO4 1011, to which I referred to earlier. You don't necessarily have to read them into the record because you have already done so.
I've read 2 of the emails into the record, or 3.
The one on page 1011 at the bottom there, from Advocate Molochwa to Advocate Chauke, is the one in which Advocate Molochwa was requesting that he be sent the prosecutor's memo.
That is correct. That's on the top of page 1012.
Was it ever sent?
Well, I think Advocate Molochwa can testify to that, whether he received it or not. I do not know myself whether it was sent or not. I do want to state that after Advocate Chauke's email, that is on page 1011, LO 1011, which I read into the record, Advocate Molochwa responded to that email, and that response is then on page 1014. It's a rather long response from Cyril Molochwa, as it is, but it's Advocate Molochwa, to Advocate Chauke, dated 13 June 2012 at 9:12 a.m. And it's a very long email, as you can see. It spans almost the entire page. But I think it's important for the panel to get the import of this email. I will read just a few lines from it. The first one is, Dear Advocate...
I beg your pardon. Is that LO 01011?
No, Chairperson, we are on LO 01014. And the email continues on 01015.
Proceed with.
Thank you. And Chairperson, we should remember the context. It's Mlotshwa asking for the indictment and the prosecutor's memo and reports. It's Advocate Chauke responding saying, who's the prosecutor you are referring to? I have forwarded you the indictment, which has all the detailed summary by which you ought to be in a position to open the file. The indictment with respect gives you the whole view of the matter. Advocate Mlotshwa then responds on the 13th of June, at 9:12 a.m. on page 1014, as I indicated. And I'll read just a few lines, Chairpersons, and you can see it's a really long email. It says, Dear Advocate Chauke, I operate from the premise that the mission of the NPA enjoins us to be guided by the Constitution. The last time I cast a glance on the Constitution, I gleaned that its preamble encapsulates that all the rights enshrined in the Constitution have to be respected, protected, and promoted. This includes the right to human dignity, which is affirmed in Section 10 of the same Constitution. He then goes on he gets quite philosophical in his email, in paragraph 2 and 3. In paragraph 2, he states, perhaps I can read from paragraph 2. You leveled serious allegations against me. You did not repeat the same allegations from your behavior. You did not repeat the same allegations when we met the ANDPP in her office. I maintain my cool through and through. The impression I derive from your behavior is that you nourish a slavish mentality. I suppose I don't need to read the rest of it into the record, Chairperson. But then he goes on to become quite philosophical. And then in paragraph 4, it is a practice within the NPA that when we send the request to the NDPP's office, which is what I explained earlier on, Chairperson, it is the practice within the NPA's office that when we send the request to the NDPP's office for the signing of the Section 2 certificate, which is the racketeering authorization of the NDPP, Chairperson, we also attach the memo to the request so that the NDPP can have an idea of what is happening in the matter before appending a signature. I explained to you when we had a short meeting in the office of the Acting National Director on 29 May 2012. I explained it when we met at the SOCA in Daba, and I explained it again when you contacted me yesterday, that the procedure in the KZN DPP office is that in order to enroll a matter in the High Court, we need two things: DPP's file and the judge's file. And then he goes on to explain what is needed for the DPP's file. He continues, you did not raise even your eyebrows during the rendition of this explanation to you. That is why my eyes popped out and my lower jaw dropped, shocked to the marrow of my bones as to what has happened now. Because in your email, you are now asking me for the first time who I am referring to when I speak of the prosecutor. If you don't have issues with me, one would not expect you to resort to forensic ambush, but would expect you to ask me as a colleague and a brother, because with the respect I always give you, I would have explained to you again. And then he continues, Chairperson, in the third paragraph of your email, this is on paragraph 5 of Mlotshwa's email. In the third paragraph of your email, you state in bold that you have learned with utter dismay that I have issued an instruction to the senior prosecutors that the dockets must be brought to me. I have been brutally honest with you. I never get excited over nothing. I'm not a person in the habit of making a mountain out of a hillock. Firstly, it was your suggestion that the inquest must be reopened. I fervently hope that you know, or ought reasonably to know, that we do not keep the inquest record in the DPP office, but they are kept by the criminal court clerks in the lower court. Chairperson, I'm just trying to read the relevant parts that would be appropriate in this.
You may leave it at that, Advocate Batohe.
Yes.
It might be helpful, counsel, just for completeness, to let the witness not choose what he wants to put. I think put the whole letter there.
Chairperson, if I may,
Because
sorry.
it may well be that we will refer to this letter in its entirety when we write. So let the witness speak.
May I clarify, Chairperson? My understanding is that the letter will be part of the record, but I was highlighting for the purpose of time the relevant parts. But my understanding is that all of the documents that we've submitted, that is my understanding, Chairperson, is part of the record. I'm happy to be guided by the Chair in this regard. Thank you,
I
Chair.
understand what you say.
Chairperson, I should say that it was after this response to complete the email chain from Advocate Molochwa. If one goes to page 1014, the top is then a response to Advocate Molochwa from Advocate Chauke saying, "Dear Advocate Molochwa, I have noted your concerns below. I apologize to you to the extent that you feel I'm not respecting you, and my communication with you was not what you expected. I also apologize for not having told you that I could not travel to KZN due to unforeseen circumstances. I hope this meets with your approval. I have learned my lesson in this regard. Thank you for your assistance so far." Chairperson, the one other aspect before we move off the emails is on page 1011, which is Advocate Chauke's response to Advocate Molochwa when he asked for the prosecution memo or report. I want to draw the panel's attention to paragraph 1, 2, 3, 4, the fourth paragraph, second one from second last one. Advocate Chauke says to Advocate Molochwa, "If this makes you uncomfortable, please indicate so that I may urgently take the matter up with the acting NDPP as well as the minister." Chairperson, for a DPP to say this to an acting DPP, to threaten, I'm not sure if that's the right word, but to report to the NDPP as well as the minister, I'm not sure what the purpose was, because the minister should not have any role in this matter, in the prosecution of this matter. So it begs the question why Advocate Chauke mentioned that if Advocate Molochwa was uncomfortable, that he must say so that he can take the matter up with the acting national director and the minister. Advocate Molochwa will testify to what he thought about that, Chairperson. Thank you.
Advocate, before you proceed, Advocate Batohi, you were asked a question whether the prosecutor's memo was ever made available or was ever sent to Advocate Molochwa, and your answer is, I do not know. Well, as the head of the NPA, one would assume, and please correct me if I'm wrong, one would assume that before you took a decision to write the letter to Advocate Chauke and to the president, you would have familiarized yourself with all the facts of the issues that you want to bring to the attention of the president. And the question that would crop into one's mind would be, how did then the racketeering charges were preferred against the Katomana group, and what happened subsequently to the exchange between Chauke and Molochwa? And I just assume that you should know the answer to this question, whether the memo was eventually made available to him or not, and bearing in mind that his acting stint came to an end shortly thereafter, whether it was then given to his successor or what happened to it, because I don't know, leaves it hanging. Thank you.
Chairperson, this matter will be dealt with in evidence, but for present purposes, I can explain that. And now, Chairperson, to understand that I'm referring to evidence, I'm referring to documents, and it's not my documents, but it's evidence before the panel. According to Advocate Malochwa, I think he says in one of his statements that he didn't hear anything further about this. But Advocate Chauke, in one of his documents, states that he did send the memo. I could be mistaken, but the process thereafter, we will explain how the racketeering authorizations came to be signed by Advocate Jipa. That is part of the evidence we intend to lead now. So that is why my answer to your question directly is whether it went to Advocate Malochwa, I'm not sure, because of what he says and what Advocate Chauke says. They need to explain that. But I know what happened in the process after that, and I will testify about that. We need to go through documents to explain that process.
Advocate Batohi, I also need to understand, because my question is along these lines. Did you investigate this matter further before you wrote the letter? Did you take it further than Mlojwa saying, I did not have any further interactions, or I did not hear anything further from Chauke from this date going forward, before you made the decision? Because in your letter you are clear. You say, I have made the decision. I have come to a conclusion that there needs to be an inquiry, or there needs to be further investigation on your conduct. So can you just clarify whether you still do not know, or what happened?
At this point, as I sit here, I do not know if Advocate Malochwa received the prosecution memo. What I do know is what happened subsequently, and my decision to refer the matter to the president was not taken at this stage. It was taken after. There's a lot of evidence in this bundle, and as we proceed now, I will explain the next step insofar as how it came about that Advocate Jiba in fact signed the racketeering authorization. I don't want to try to explain it now because we've got lots of documents to go through, and I might get caught up in that process, but I do not know if Advocate Malochwa received it or not.
Should I take it that you are treating us, you're giving us information on a need to know basis? So we will know this information when the time comes, but for now we should just put it on hold.
No, absolutely not. I want to give the panel all the facts as far as I'm aware of. So I can run through what happened after that without referring to documents.
I didn't mean that you should not be late. Thank you.
Thank you very much.
Madam Baloyi, may I proceed?
Yes.
Advocate Patohi, I'm of the view currently that I should refer you back to Advocate Malochwa's email, which you earlier referred to. I'm fortified, in my view, by what Madam Chair has indicated, that perhaps it is prudent to read the whole document. But for the moment, do not read the whole document for the moment. Just go to paragraph 8 on page 1015.
1015.
LO 01015.
Perhaps we should clarify to the panel, lest they get confused, that there's some duplication of documents. We were referring to 1010 and 1015, but they appear to be the same email. Just,
I beg your pardon. I think council is referring you to something else.
I apologize,
If you
Chairperson.
can go to what council is taking you to.
1015,
One
Chairperson.
L0 LO01015. Correct,
01.
council?
That's correct.
That is
Madam
where
Chair.
I am, Chairperson. It is a duplication. That's all I wish to say. Of 011010.
Pardon me, it's the one that is embedded in my mind,
Thank you.
apart from the previous one.
Sure.
But then go to paragraph 8 and read the whole thereof.
Paragraph 8 states, I have not changed my mind. I still need help from you because I want perpetrators of crimes to answer for their atrocious deeds. Only if we can respect each other and acknowledge that we all enjoy the right to human dignity. The AJP stated that he will meet us on Monday in Pietermaritzburg. I am still requesting you to give me a brief report so that I can also assure myself of what I am signing on. Again, humility and modesty will help us in this regard.
Thank you. Go to LO1, which you just
LO?
page 178.
Yes.
You read
I'm there.
paragraph 25, not so.
I did.
Paragraph 26, may you read it into the record? We're still on Dr. Broughton's
Yes.
supplementary affidavit, rather supplementary opinion, not so.
Yes. The chair can assist. I think I read paragraph 26 into the record already.
Did you? My apologies.
I can be corrected.
Which paragraph? Are you looking at LO00149
178.
or 170?
Yeah, she says she has read it into the record.
It's paragraph 26.
Yes, paragraph 25, 26 were read into the record.
Proceed then. Thank you, Madam Chair. Proceed then to paragraph 27 on the next page, 179.
Advocate Mlotshwa was then removed as acting DPP KZN on 9 July 2012. Advocate Noko was appointed as the new acting DPP of KZN on 12 July 2012, which appointment would come into effect as from 16 July 2012. The removal of Advocate Mlotshwa as acting DPP and the appointment of Advocate Noko as acting DPP was on the recommendation of the acting national director at the time, Advocate Jiba, as per the latter's memorandum to Minister Hadebe, dated 26 June 2012. Should I read the rest of it as well? It deals with Nkabinde Enquiry.
You don't have to. You don't have to. Go to paragraph 28.
Paragraph 28, it is striking to note that the very next day after Mlotshwa's acting appointment as DPP was terminated, an application dated 10 July 2012 in the name of Advocate Chauke for racketeering authorization to be issued by Advocate Jiba was submitted by the Boyson prosecution team to the NPA National Office, VGM, in brackets VGM. This is according inter alia to the affidavit dated 17 May 2012 of Advocate Gladstone Maema, in brackets Advocate Maema, a DDPP of the Northwest DPP Division, who was the lead prosecutor on the Boyson prosecution team. Advocate Maema's affidavit was deposed to, for, and presented to the SEC, that's the State Capture Commission. The said application, I continue, is attached here too in the evidence bundle as Annex to C. The application is an exhibit that was annexed to Advocate Maema's affidavit marked CM77. The application is unsigned. It should be emphasized that I conducted a diligent, I meaning Dr. Broughton, who's writing this. It should be emphasized that I conducted a diligent search at VGM for the 2012 racketeering file pertaining to the Boyson prosecution, but to no avail. This file can seemingly not be located at the present time, which with respect is disconcerting. So while it is so that Advocate Maema appended an unsigned version of the application to his SCC affidavit, it may be that a signed version was submitted at the time to the VGM. Why would such an important application be submitted to the VGM unsigned? Needless to point out that it is undated, needless to point out that in his undated but signed affidavit of November 20th and presented to the State Capture Council, State Capture Commission, SCC in short, Advocate Advocate Mosing, a DDPP of North Gauteng DPP Office, Pretoria, who at the time was the head of the Special Projects Division, SPD, in the office of the NDPP, in brackets ONDPP, fulfilling inter alia a coordination function in the receiving and processing at VGM of racketeering authorization applications and advising the NDPP on the authorization of racketeering prosecutions. He states that on about the 10th July 2012, he received the aforesaid application for racketeering authorizations from the prosecution team under cover of the letter from DPP South Gauteng. Relevant excerpts of Advocate Mosing's affidavit to the SCC are attached hereto in the evidence bundle as Annexure D. Chairperson, I should, for clarity, state that the Annexure C and Annexure D that Dr. Broughton refers to were marked as annexures to his supplementary affidavit.
Now, I want to take you to
Council, if I may. I'm sorry, Advocate Batoy, to interpose.
Mhm.
It occurs to me, Advocate Mutlamunyani, that since we started, we have been referring to a list of documents which are not marked exhibits. What we request you to do, or your colleagues to do, at the end of this testimony, please give us a list before we close. A list of all those exhibits properly marked, following from the last marked exhibit.
Will do so, Madam Chair. If perhaps the last one that I remember was Exhibit 2. We never had any subsequent. If my
Had
memory
two
serves.
exhibits.
Yes, we had 2 exhibits
Yes.
that were marked.
It means, I don't want to keep on interrupting you. That's why we request that you bear that in mind before the witness steps from that box. You place on record the list of all these exhibits, properly named, so that they can be properly placed on record.
In other words, Madam Chair, correctly, before we adjourn these proceedings for today, it has to be placed on record, properly placed on record.
It will be helpful if you can do that with the assistance of your colleagues. I know your junior is not here, but it will help us so that we have a complete record for today. Because you are referring to this document as referred to in the affidavit itself. But for the purpose of this inquiry, we must mark them so that they can be properly bundled as exhibits. Will it be possible for you to do that at the end of business, when you finish, before Advocate Batoi leaves the stand?
May I inquire from the NPA's team as to whether they will be able to do that? I'm informed by the NPA team that they will attend to that, Madam Chair.
Yes, thank you.
Thank you, Madam Chair. Advocate Patohi, what you were reading from that document has an impact on paragraphs 3, 3.1, 3, and 3.1.1 of the terms of reference. Can you confirm that?
That is correct.
You referred to a date of 10 July 2012 where an authorization certificate was applied for. We'll revert later to that. For the moment, I refer you to LO2 00376, which contains an affidavit deposed to by Advocate Anthony Musing. It starts on page LO2 LO 00340. Are you there?
Please take us to that bundle,
Bundle LO2, Madam Chair,
LO2.
LO 00340. That's the page. That's where it starts.
340.
Yes, 340. That's Anthony Musing's affidavit that served before the State Capture Commission. Now, go to page 376.
Yes,
Advocate
I am.
Patohi, are you there?
I'm there.
We have to look for the bundle. Council. You are referring us to LO2.
Bundle LO2, Madam Chair.
Please give us a second.
I'll do that.
Thank you, Council.
Thank you, Madam Chair. Advocate Patohi, for completeness' sake, who is Advocate Anthony Musing?
Advocate Mosing, if my memory serves me right, held the position of a Deputy Director of Public Prosecutions.
Where was he stationed?
He would have been stationed at the time of these events at the NPA head office, at the VGM office as it is referred to. And it appears he was in charge of a special projects section, and that I've gleaned from the other document. But perhaps to clarify what it appears his role was at the time regarding racketeering, and I stand to be corrected. It's my understanding is that he would have then received racketeering applications. He was in the office of the NDPP. He would have received applications from various parts from prosecutors across the country. And then he would process the documentation and prepare it for submission to the national director for her consideration, the acting NDPP at the time. That's my understanding of his role.
And at the time, the acting NDPP was Advocate Jiba.
That is correct.
As at 2012.
That is so.
Go to page LO 00376 of bundle LO2. Are you there?
I am.
LO2, page LO 00376, Madam Chair. Go to paragraph 95, that is the affidavit of Musing, Advocate Anthony Musing. Please read paragraph 95 into the record.
So Advocate Mosing states at paragraph 95 of his affidavit, on or about 10 July 2012, I received an application for racketeering authorizations from the prosecuting team under cover of the letter from DPP South Gauteng. After considering the application, it was concluded that the application must be made by the DPP KZN, as the DPP South Gauteng had no jurisdiction. Subsequently, on paragraph 96, Counsel, should I stop there or continue?
Just read it, and then we'll go back to paragraph 95.
Sure. Subsequently, on or about, this is paragraph 96. Subsequently, on or about 15 August 2012, I received the application for racketeering authorizations from the prosecuting team under cover of the letter from DPP KZN. On or about the same time, I also received an application for centralization under cover of a letter from DPP South Gauteng.
Now, go to the same bundle, LO2, to page 297, LO 00297. Therein, you will find an application for authorization. Indeed. It's an application for authorization, Madam Chair. Yes, it's on page 00297 in bundle LO2. Are you there, Madam?
I am.
Thank you.
Now, this application on this page is dated 10 July 2012. Do you see that?
That is so.
If you go back to paragraph 95, which you earlier read into the record,
Yes.
is it the same
It appears that
application that Advocate Musing was referring to?
it appears to be the same. When in paragraph 95, he says he received an application for racketeering authorizations under cover of letter from DPP South Gauteng. And this is, that is LO 00297. The document there is a memo from Advocate Chauke to Advocate Jiba dated 10 July 2012. And the subject is application for authorization in terms of Section 2.4 of the POCA Act, 121 of 1998, in the matter of the State versus Boyson, Johann Wessel and others. And an application, Chairperson, in terms of Section 2.4 of the Act is a racketeering application. If I may, the body of that document states here with the following: the application for the racketeering certificate, I paraphrase phase 1.1. 1.2 is the draft indictment. 1.3 is the draft authorizations for Section 21E and 21F respectively. And that would be in terms of the Prevention of Organized Crime Act, which relates to racketeering offenses. Paragraph 2 states, I have perused the documents and recommend the application. And paragraph 3 states the accused have appeared in the Regional Court Durban. Matter has been postponed to 24 April 2012 for the racketeering authorization. 18 of the accused persons are on bail. Other accused still need to be added to the charge sheet and indictment. And there's a place for signature by Advocate KMA Chauke, DPP Johannesburg. The document is unsigned.
In paragraph 1.2, it refers to the draft indictment. If you
That
go
is
to the
correct.
next page, LO2, LO00298. Explain that document there.
So this document on that page, as well as the following page, would be the documents referred to in paragraph 1.1. Well, actually, it's 1.3. It would be the draft authorizations. So if the National Director, Acting National Director, Time Advocate Jiba was satisfied, she would have signed these documents, which are the draft authorizations.
Go to the next page, LO2, LO00299.
Yes, that's also a similar document for a certification by the National Director that he or she is, in this case, Advocate Jiba, is approving the authorization for racketeering charges.
Go to the next page. The following page is 300.
Before you do that, Council, L000299, is that the page you've just referred to now?
It's a draft according to the
It
witness.
is a draft.
It's a draft. Let me find out from the witnesses who prepares these drafts.
No. I just want you to tell me because I see LO 00299 supposed to be an authorization under the hand of Advocate Jiba, but it is not signed.
Indeed, Madam Chair, it's unsigned. Go to the next page where you find a prosecution memorandum. Explain what a prosecution memorandum is.
The prosecution memorandum would normally set out the case against the accused persons, setting out the charges as well as key aspects of the evidence.
In the normal course of events, Advocate Batohi, it is imperative that such a memorandum, referred to as a prosecution memorandum, should be annexed to authorization applications in terms of section 2.4 of POGA.
That is correct. And this is what this bundle appears to be. It appears to be the first document being the memo, which is always signed by the DPP of the jurisdiction where the case is taking place. And to that will be a bundle which would be attached, the draft authorizations, as well as the prosecution memo and the indictment. Often
I see on page 301, if I may refer you to it.
301.
301, under paragraph D, subparagraph D, there's identification of the accused there. Is that what you refer to as an indictment?
No, this is
What
part.
is this?
This is part of the prosecution memorandum, which starts on the page before that, LO 300, and continues. So that is the prosecution memorandum. It's part of that document. But it identifies the accused.
It identifies the accused.
Yes, that's correct.
You go to the next page, the page that follows the identification of the accused. On page 305, LO 305, there is analysis of evidence.
That's correct.
The next page contains a list of proposed charges.
That is correct.
Is that the indictment?
No, it isn't. It is still part of the prosecution memo. If you look at the page numbers, they follow, and it appears that this prosecution memo proceeds right until page 43.
Three,
LO 3339. So that's one document, the prosecution memo. And I should indicate that, no, I think that's all for now.
now, what is contained in this letter, in this application for authorization that you referred to earlier, dated 10 July 2012, together with the prosecution memorandum.
Sorry, just a moment. If you take me there again.
I'm taking you back to LO2, LO 00297.
Yes, I'm there.
I'm saying what appears there, together with all the attachments, to this application.
Yes.
In,
As I indicated, it's a memo from Advocate Chauke,
yes,
the DPP of Johannesburg,
yes.
to Advocate Jiba,
My que-
the acting national director.
yes. My question is, what appears there, the application itself, together with the memo, including what you have read in paragraph 95 and 96
Yes.
of Musing's, Advocate Musing's affidavit, pertains to paragraphs 3, 3.1, 3.1.1, and 3.1.1.1.
That's correct.
Advocate Mutlamunyani, the memorandum is signed, or rather is drafted by Advocate G.S. Maema.
Indeed, Madam Chair, and that appears on page 339.
Now, when you look at the terms of reference, paragraphs 3.1.1.4 and 3.1.1.5, of what relevance is this memo to all these, at least to the two paragraphs I have referred to,
3.1.1.
0.4 and 3.1.1.5 of the terms of reference?
I don't remember mentioning 3.1.1.4, Madam Chair. I don't remember. I said 3.1.1.
I'm not suggesting you did. I'm asking a question for my own clarity, just to understand the relevance of this memo, the pages that you've referred us to, insofar as the terms of reference are concerned.
For the moment, it doesn't pertain to paragraph 3.1.1.4 of the terms of reference, but it has a bearing and an impact on paragraphs 3, 3.1, and 3.1.1, as well as 3.1.1.1.
Thank you.
Thank you, Madam Chair. We now know that this application was prepared by, it would appear it was prepared by Advocate G.S. Maema. Am I correct?
That is correct.
Now, what was the role of Advocate G.S. Maema?
According to the information, he was the team leader of the prosecution. He was the leader of the prosecution team.
Was the leader of the prosecution team not Mr. Maema?
Sorry, what name did you, I apologize, Chairperson, what name did?
Advocate G.S. Maema.
Yes.
Advocate Maema.
In terms of the team that is, so you have a DPP, and then you have the prosecutors that are actually the ones that are going to prosecute the matter in court, and that deal with the management of the case itself in terms of the evidence and managing the case. So you have, it appears from, I think the paragraph 60 that you referred me to earlier on, evidence leader, chairperson, that he was the team leader.
Advocate Maema.
That's correct.
Yes.
Yes, that's
Not
correct.
Advocate Chauke.
Not the leader of the team. Was the DPP in charge of the team, and Advocate Maema was the prosecution team leader.
Yes, leader.
Thank you, Chairperson.
Thank you, Council.
Thank you, Madam Chair. Go to page 00777, 777, in the same bundle, in which you will find an email trailing there. Page
777.
Yes, 00. Triple seven.
The last page of L02 seems to be page 664.
Yeah.
Which document are you referring to? I could assist.
In the
May-
index,
Yeah, may I take instructions?
777 will be your annexure H of Musing. Maema email 2012 0815 Musing affidavit parenthesis capital A 12 close. Is that a document?
Yeah, that's the document, Madam Chair. My junior has assisted me. She says it must be contained in LO3.
L3.
Indeed, Madam Chair. That is correct. It's LO3. Advocate Patohi, have you located the document?
Yes, I have.
It's an exchange of emails between
is so.
Advocate Mahema and Advocate Musing, not so.
That is correct.
Can you read into the record the email on top of the page and go down the page?
The email from Advocate Silo Maema, to Advocate Musing.
Indeed, Madam Chair, but emails trail seems to confuse us. They start at the
From the
back.
back.
I should have started at the back, Madam
If
Chair.
you're confused, I'm more
Eh,
confused.
Email trailings. It starts, Advocate Patohi, on page 779.
Yes.
And then it means that the first email trailing was from Anthony Musing at the bottom of page 778. Do you see that?
Yes, I do.
Dated 14 August 2012 at 4:21 p.m. And it was directed to Mahlubi Ntlakaza and Sello Maema.
That's correct.
Are you able to explain what is contained there? What was the message?
So this email, what I gather from what's here is that it is, as you said, from Anthony Mosing to Advocate Ntlakaza and Maema. And if one notes the team earlier on, Advocate Maema is the prosecution team leader and Advocate Ntlakaza is one of the members. The subject is final Cato Manor indictment as modified by Advocate K.R. Matenjwa. And Advocate Mosing says, colleagues, herewith more corrections to the summary of facts and the memorandum. Regards. So one can infer from that that he had made corrections to the documents that he had received earlier on, under cover, as he said, of, I think it's letter dated, the memo dated 10th August that we were referring to earlier on.
Go to the one following that one on the same day, the 15th of August,
The next day.
the next day at 8:34 a.m.
So Advocate Ntlakaza responds to well, he doesn't, it's a letter from, it's an email from Advocate Ntlakaza to Advocate Matenjwa, Molochwa, Moleko, Fuchane, Maputa, and copied to Advocate Maema. These are minor changes to the enterprise only. I think we can get our certificates. I'm not sure whether Advocate Maema has printed the hard copies. I'll be at the Constitutional Court today.
So the subject there was a final Cato Manor indictment.
Yes, it's from this email. It's clear that they were preparing to get this racketeering certificate from the acting national director.
Go to the next one. That follows, it's up the page, in the middle of the page,
It's an
at 12:02.
It's an email from Advocate Maema to Advocate Mosing, Matenjwa, and copied to other colleagues in the team.
Can you read it into the record?
It states, dear colleagues, Anthony, and that would mean Anthony Mosing because his first name is Anthony, it would be Advocate Mosing. Anthony, I had a look at the proposed changes. It is more to complete the participants of the enterprise to include the Port Shepstone organized crime accused. I have worked it into the indictment at the whereases, at the summary of substantial facts, and into the prosecution memo. You asked whether we are not repeating the same paragraph at the summary of the case in the prosecution memorandum. I think it completes the introduction well and is not necessarily repetition, although it has been mentioned at the introductory part. He then goes on to say in paragraph 2, we have also added Lockham and Van Tonder as managers of the enterprise. I will make contact with you today or tomorrow to bring the hard copies. And this is important. I have also done the prosecution memo on the KZN letterhead, comma, although our DPP, which I assume is Advocate Chauke, will sign as arranged with the acting DPP KZN. Thank you for your valuable contribution. We await your facilitation for the approval of the racketeering certificates. Remember, we require them next week. We apologize for putting you under pressure. So it was clear from that that there was a lot of pressure in terms of getting these certificates authorized.
With that, am I correct to assume that at this stage, Advocate played no role whatsoever?
He's played no role in getting these documents together for the purpose of submission. That's also an inference that I make, Chairperson.
The assumption. The assumption.
I beg your pardon, not an inference, the assumption. Thank you.
Thank you, Council.
Thank you, Madam Chair. Advocate Patohi, you remember you were reading in LO1 that Advocate Molochwa's tenure ended. Remember that?
Yes.
It ended on the 9th of July, if my memory serves me well. Yes, 9 July 2012, not so.
Yes, that appears to be the case.
Thereafter, Advocate Noko was appointed as the acting DPP KZN, not so.
That is correct.
From memory, can you remember when she took office?
I know she was, I think it was mid-July. From memory, I think it was the 16th of July, but I stand to be corrected.
Beg yours?
I said, I think it's the 16th of July, but I stand to be corrected. It is in one of the documents.
Yes, let me refer you to a document contained in ZC 11. ZC for Zondo Commission.
Yeah, I just need to find the bundle, please. Council. ZC 11.
I'm told it's in one of your bundles, Advocate Batohi. ZC 11. ZC 11, page ZC 02708. I will repeat it for the benefit of everyone. I'll repeat the page. Have you located it?
I have, yes, thank you.
It is a letter.
Please give me a second, Council. Page?
Page ZC 02708. It is a document prepared by the Office of the National Director of Public Prosecutions, addressed to JT Khadebe, MP,
Please give us a second to locate this document. Is ZC 0208.
7, indeed, Madam Chair. Are you there?
I am.
Perhaps you must read the introductory part of that letter because the marking here is obscured by something else. The numbering in our record is obscured by some kind of deletions.
But you got the page?
Yes,
If you may read it, if you may write it by hand, maybe.
It is a document from Advocate Jiba to MP, to the Minister, I suppose. Hadeb. Is that the document?
That's the document, Madam Chair.
Thank you.
May I proceed?
Yes, sir.
Please, Advocate Patohi, read the document into the record.
The entire document. Okay, I'll go ahead.
Yes, the entire document. It's important.
Sure. It's a memorandum that is from Advocate Jiba as acting NDPP to Minister Khadebe, the Minister of Justice and Constitutional Development. It is signed by Advocate Jiba on the third page of 26 June 2012. That's ZC 2710. The subject line is request for appointment of an acting Director of Public Prosecutions, jurisdictional
I beg
area.
your pardon, Counsel. I'm sorry, Advocate Batoi. You said SON 2. Did you say SON 2 or signed?
Signed, I beg your pardon, signed on the 26th of June 2012.
Yes, it's not an affidavit.
No, it's a memorandum.
It's just a memo.
That is correct.
Yes.
A memorandum from Advocate Jiba to Minister Khadebe. The subject line is a request for appointment of an acting Director of Public Prosecutions, jurisdictional area of KwaZulu-Natal High Court Division, Section 13.3 of the National Prosecuting Authority Act 1998, 32 of 1998. The purpose, one purpose of the memorandum is to request the appointment of Advocate Mopone Noko Mashilo as the acting Director of Public Prosecutions for the KwaZulu-Natal High Court Division. Paragraph 2, Section 13.3 of the National Prosecuting Authority Act provides as follows. Appointment of directors and acting directors. Subsection 3, the Minister may from time to time, but subject to the laws governing the public service and after consultation with the National Director, from the ranks of Deputy Directors or persons who qualify to be appointed as Deputy Director as contemplated in Section 15.2, appoint an acting Director to discharge the duties of a Director whenever the Director concerned is for any reason unable to perform the duties of his or her office, or while the appointment of a person to the office of Director is pending. And then below that it says request for appointment. I think that's the subject of the memo. B is background. Paragraph 3, the Minister has due to Advocate Batoy's secondment to the International Criminal Court in November 2009 and a subsequent resignation from the NPA, from the National Prosecuting Authority in April 2012, appointed various Deputy Directors to discharge the duties of Director of Public Prosecutions in KwaZulu-Natal, the most recent being Advocate C.S. Malochwa. Paragraph 4, to ensure adherence to the prescripts of the Senior Management Service Handbook and that no expectation is created by an extended acting appointment, I deem it necessary to request the appointment of another Senior Deputy Director to act as DPP for the period 16 July 2012 until further notice. or until the vacant post is filled. It is thus hereby requested that Advocate Moipone Noko Mashilo be appointed to act as DPP for the requested period. Advocate Noko Mashilo is a Level 14 Senior Deputy Director at the DPP office in Pietermaritzburg. She is a competent, committed, and dynamic person, and I am of the opinion that she will be able to execute her duties of acting DPP. C. Recommendation. It is recommended that Advocate Moipone Noko Mashilo be appointed in terms of Section 13(3) of the Act as acting DPP for the period 16 July 2012 until further notice or until the vacant post is filled. Attached, find a draft appointment for your consideration, Annexure A, and it's signed by Advocate N. Jiba, Acting National Director of Public Prosecutions, dated 26 June 2012. And below that, the recommendation, paragraph 6, is approved. Draft appointment signed, comments none, and it's signed what appears to be by Minister Hadebe it appears to be 12th of July, 2012. I'm not sure if it's 02 July or 12 July. It's unclear. It might be 02 because if you look at the next, I'm looking at the next document, which is 02 ZC 02711. It's the appointment letter that's signed by Minister Hadebe, appointing Moipone Noko Mashilo as Acting Director of Public Prosecutions for the jurisdictional area of Natal Provincial High Court Division, or the High Court, for the period of 16 July until 2012, until further notice or until the vacant position is filled. And this is signed clearly at Pretoria on the 2nd day of July, 2012, by the Minister of Justice.
Yeah, whilst you're still there, let us go back to the Act, the NPA Act, National Prosecuting Authority Act.
Okay.
Go to Section 13 and confirm whether this appointment of Advocate Moipone Noko Mashilo was done in terms of Section 13.
That's correct, as the memo indicates.
Now, the appointment says, for the jurisdictional area of Natal Provincial High Court Division.
Yes, that's the appointment letter that's signed by the minister.
Can you explain that jurisdictional area? What does that imply?
Well, it means that Advocate Noko Mashilo is appointed as the acting DPP for the KZN division.
Go to LO3, page LO 00665.
Before you go to that bundle, Council, what is the import of that letter that has been read into the record? The appointment of Advocate Noko? Is it merely to place on record that Advocate Mlocho was replaced?
Not only that, but it will also show subsequently that what the role of Advocate Noko Mashilo was in the Katomana episode.
Thank you, Council. You may proceed.
Thank you, Madam Chair. Are you there, Advocate Batohi?
I am.
You you see that there's a letter. In fact, it's an application for authorization in terms of section 2 in brackets 4 of POCA.
That's correct.
May you kindly read it into the record?
So this is an application, it's a memorandum from on the letterhead of the Director of Public Prosecutions, KwaZulu-Natal.
Take us to the yes, Council. Thank you. May proceed.
Thank you, Madam Chair. May you proceed, Advocate Batohi, to read that letter into the record.
It's a memorandum from, it's, as I said, it's on the letterhead of the DPP KwaZulu-Natal. It's from Advocate M. Noko Mashilo, the acting DPP of KZN. It's dated 16 August 2012. The subject is application for authorization in terms of Section 2.4 of the POCA Act of 1998, State versus Boyson, Johann Wessel, and others. Then goes on to say the following, herewith the following. 1.1, application for authority in terms of Section 2.4 of the Prevention of Organized Crime Act 121 of 1998 for your consideration and approval. 1.2, the proposed indictment. 1.3, the draft authorizations for Section 21E and 21F, respectively. Paragraph 2 is important. It states, I have perused the documents and recommend the application. 3, accused have appeared in the Regional Court Durban, and the matter has been postponed to 24 August 2012 for the racketeering authorization. 18 of the accused persons are on bail, and 12 other accused persons will be added to the charge sheet. The name of Advocate Noko Mashilo as the acting DPP KwaZulu-Natal appears at the bottom, but the document is signed by Advocate Chauke. Chairperson, perhaps to state that this document is identical to the unsigned memorandum that was referred to earlier, which is on LO200297. And it appears from the evidence I've already tendered that after that communication between Maema and Mozing indicated that there must be a memo prepared by the, I don't have the language in front of me now, but prepared by the DPP KZN, but the email goes on to say, but it will be signed by our DPP. I assume referring to Advocate Chauke, and this document is indeed signed by Advocate Chauke. Thank you, Chairperson.
Advocate Batohi, are you identifying the signature appended on this page 00665 as that of Advocate Chauke?
Yes, that's correct. I know his signature, he submitted documents. On that basis, I say it's his signature.
You're referring to LO00665.
That is correct, Chairperson.
And above the name Advocate M. Noko Mashilo, there's a signature there.
That is correct, Chairperson.
Are you saying it is Advocate Chauke who signed this?
That is correct, Chairperson.
It is common cause that you took office in 2019.
The current office, yes.
Yes.
That is so.
As NDPP.
That is so.
For how long have you...
If you may remind me, why would Advocate Chauke sign and not Advocate Noko Mashilo? Because
Chairperson,
he does not seem to sign PP there.
Chairperson, the evidence that we tendered earlier, and the evidence leader will help me perhaps go to those documents, but I can paraphrase, Chairperson. What transpired from the documents we referred to is that if one looks at in bundle LO2 00297, there was originally a memorandum identical to this one, prepared, but in the name of Advocate Chauke for signature. The communication then between Maema and Mozing, it was Mozing, in fact, I think, who raised in one of the documents that Advocate Chauke cannot sign this memorandum because he doesn't have jurisdiction. I'm paraphrasing, Chairperson. What then happens is that there is an email which we've already led evidence on and referred to the emails that Advocate Maema, I think, writes to Advocate Mozing saying that they will prepare the document in the letterhead of KZN, but it will be signed by our DPP. So in effect, what's happening is the impression, this is my deduction, Chairperson, is created that this matter is in fact being dealt with by KZN, but is signed by Advocate Chauke as the DPP in this matter.
That's when you made an assumption that reference to DPP in that document referred to Advocate Chauke. You remember I asked you that question. When you said you are drawing an inference, and I said you are making an assumption. Is that the document?
My memory is not that great, Chairperson. I'm just trying to make sure I respond. I'm responding to the correct document. I do remember your question.
Yes.
But I'm just want to make sure it's linked to this and I answer properly.
In that letter, if I'm correct, Counsel, it is Advocate Maema who was writing and saying they will refer those documents to our DPP.
Yes.
And then I beg your pardon, may I finish? And then you then said, you drew an inference, and I said you are drawing an assumption that DPP there refers to Advocate Chauke.
I recall, Chairperson.
Now I'm asking you a question on LO00665, where you have that letter from Advocate Noko Mashilo, Acting Director of Public Prosecution, KZN, to Advocate Jiva. Now, the document, that letter by Advocate Musing, is under his name or her name. I'm not sure whether it's a lady or a gentleman. It's a lady, I suppose.
It's a gentleman, Chairperson.
It's a gentleman. There's a signature there, but it doesn't appear to be PP. I would have imagined that Advocate Noko Mashilo would sign this document.
It's not her signature, Chairperson. It's Advocate Chauke's signature.
Yes. It's not PP. It's not done PP.
I can't tell, Chairperson. That's his signature.
My colleague is saying Advocate Chauke signed PP. Can you confirm that by looking at that document?
Chairperson, he's certainly signing for Advocate Noko Mashilo. I don't know whether that's part of his signature. Whether there is a PP, whether the arrow is meant to be PP or it's part of his signature. It could potentially be a PP, not but Chairperson, but it's his signature and it's Advocate Noko's below, name below.
Advocate Batui, You have indicated to the panel that you know the signature of Advocate Chauke. Now, according to your knowledge, does the signature of Advocate Chauke ordinarily entail that arrow that you say you do not know? That seems to be also confusing you. Let me put it that way. Does it ordinarily entail that too?
I don't know, Chairperson. I'll have to look at another signature of his to compare. But I know that looks like his signature, and I don't think it's disputed that it's his signature, Chairperson.
Yeah, just focus on what I'm asking. I'm asking about the arrow. And your answer is that you do not know. You are going to ascertain and look at other signatures. Is that correct?
I can do that, Chairperson.
Right, thank you.
Can I piggyback from that, just for my own clarity? Why would Advocate Nokomo Singh write a letter, put his names there, and his position as the Director of Public Prosecution, KZN, and he doesn't sign the letter, and he causes someone else who is a DPP, Gauteng South, to sign?
That is an important question, Chairperson. And perhaps if we can refer back to the email, if Council will help me, this might help us understand this. The email of Maema to Mosing.
May we refer to him as Advocate Maema, please?
Sure, Chairperson. Advocate Maema to Advocate Mosing.
If I may assist, Madam Chair, is a lady.
I beg your pardon.
I just wanted to assist in that regard as far as
I can't hear you, Council.
I wanted to assist in regard to Advocate Muipone Nokomashilo. She's a lady.
She's a lady.
Yes.
Thank you. Thank you, Council.
If we could go to that, the email, which will help me explain, answer the Chairperson question about why would Advocate Chauke sign. If you could just direct us to that.
Yes, it's in 778, LO3.
778.
LO 00778, Advocate Patohi.
Yes, thank you. Chairperson, again, it's an email from Maema to Mosing, where they are preparing the documents for submission to the National Director for the authorization or the approval of the racketeering certificates. If you look at the middle paragraph, I have also done the prosecution memo on the KZN letterhead. Although our DPP will sign as arranged with the acting DPP KZN. That will perhaps assist in explaining that, Chairperson. That's correct, Chairperson. That is correct, Chairperson.
Pardon? When one looks at the email at LO 00778, the date is 15 August 2012, and the letter that is written by Advocate Nokomashilo is also dated 15 August 2012. It is on that basis that we made the assumption.
That is correct, Chairperson. And if you look at the email that you referred to, it is from Selo Maema.
Yes.
And if we go to LO 00703, which is attached to the memo at LO00665, it is signed by Advocate Maema.
It is signed by who?
Advocate Maema, the same person who sent the email that we just referred to, Chairperson.
00778.
That's correct, Chairperson.
Yes, thank you.
I have a follow-up. Advocate Batohi, if you can assist Advocate Maema, from which jurisdiction is he?
He is from, well, he's now retired, but at the time he was from the Northwest jurisdiction and was part of this team.
Northwest Division.
That is correct, Chairperson.
Now, if he say, I have also done the prosecution memo on the KZN letterheads, although our DPP will sign as arranged with the acting DPP KZN. How do we place the DPP South Gauteng in the sentence when Advocate Maema is from Northwest?
Chairperson, at the time, the evidence will show this team was put together and they were working from the VGM in the head office in Pretoria. So the team was predominantly from Johannesburg, and I'm not sure how many, Advocate Maema might have been the only one from Northwest, but they'd come together in VGM Pretoria, and they were working from the VGM office, head office, on these cases. So he was not physically at the time working in Northwest province. So he was part of the team that at the time was activities of this team was being coordinated by Advocate Chauke. So the DPP Northwest didn't have anything to do with this matter.
The VGM offices, I take it they are in Silverton,
That is correct, Chairperson. It's a head office of the NPA.
and they would fall under the jurisdiction of Pretoria.
That is correct, Chairperson. The office is in Pretoria.
So the DPP there would be DPP Pretoria.
The VGM is in the jurisdiction of DPP Pretoria. That's correct.
Kate Batohi, I'm trying to make sense of the use of our DPP and marry it to Advocate Chauke. If you can assist me with that link.
Sure. Chairperson, the understanding is that there was a team that was put together. And if we look at paragraph 60 that we referred to earlier on, that sets out the team.
Yes,
Is that 60 of
in Advocate, but Advocate Chauke's witness statement.
if we could just be directed to that part, I will be helped to answer the question better. Because what practically happened is that prosecutors from Johannesburg, and this is my understanding, and I'm sure there'll be others that will be better placed because, as I said, I was not here at the time. I'm gathering from other bits of evidence, so it's not my direct evidence. But my understanding is that this team was put together. If we can be directed to that paragraph and the page number, it will help. But my understanding is that this team of prosecutors working on this case were working from the Pretoria of the VGM office under the DPP Gauteng, that South Gauteng, that is Advocate Chauke, and dealing with these cases that actually emanated, this particular case emanated from KZN. That is my understanding of how this worked.
May I refer you, therefore, for purposes of understanding and for purpose of answering Madam Baloimere's question to paragraph 60 of LO1 on page LO 00266. Just to recap, you have already dealt with it, but for purposes of answering the question, it is appropriate that you should go back to it. It's in LO1, Madam Chair, and the page is LO 00266. And if I may point out, my colleague informs me that it's almost lunch break.
Yes, I've noted that. I just want us to wrap this aspect so that we don't forget where we ended. Is at LO 00266,
That's correct, Madam Chair.
paragraph 60.
Paragraph 60 thereof. This is a witness statement of Advocate Chauke that served before the State Capture Commission.
Yes. That he was asked by Advocate Jiba to put together the team.
Indeed, Madam Chair.
He says, according to that paragraph 60, Advocate Chauke states, Jiba requested me to assist with putting together a prosecution team which will guide members of the police and members of IPID, the Cato Manor team, on the investigation and prosecution of the matters. I agreed to be the coordinator of the prosecution team. The prosecution team was comprised of the following advocates: Advocate S. Maema, DDPP, team leader. Now, he was at the time, my understanding is, I'm not here, and Advocate Chauke will be able to better testify to this, a DDPP in Northwest, but working now as part of this team, the team leader, in fact. Advocate Matenjwa, DDPP, my understanding is that he was based in Johannesburg at the time. Advocate Ntsakaza, I'm not sure which division he was from. Advocate Molochwa, I think was also from Johannesburg at the time. Advocate Fushane was from Johannesburg. And Advocate Moleko, I don't know from which division.
Whilst you're still there, let me interpose. When you refer to Advocate Molochwa, make a proper distinction between this Molochwa and the Molochwa in KZN.
That is correct. They are not
Yes.
the same. They are different persons.
This one is
Different people.
This one is referred to as Advocate JJ.
Yes,
Molochwa.
that's correct. The other one is Simpiwe Molochwa.
And the document on page 665, the memorandum that you referred to earlier, which was signed by Advocate Chauke, together with the documents attached thereto,
So
Have
665 on which bundle?
LO3,
Yes.
the memorandum of 15 August
Yes.
signed by Advocate Chauke,
Mhm.
have an impact on paragraphs 3, 3.1, 3.1.1, 3.1.1.1, and 3.1.1.2 of the terms of reference. Can you confirm that?
That's correct. And I should mention that the second paragraph, which states, I have perused the documents and recommend the application. The applications to the National Director for Racketeering are submitted by the Director of Public Prosecutions from the jurisdiction where the case emanates, which is normally the case, and the DPP must be satisfied that there is sufficient evidence to support the application and then would recommend the application, Chairperson. And in this case, it appears that Advocate Chauke is recommending the application. Whether it's on behalf of Advocate Noko, I think she needs to explain, but that's the position.
Perhaps to answer the question by my sister, Advocate Baloy SC, a very pertinent answer could be at LO 00267, paragraph 62.4. Advocate Mushamuyane, where It reads, this is Advocate Chauke speaking. 62.4, and correct me if I'm wrong. Feedback and briefing on the team to JIBA, including the submissions of documentation from the prosecution team to the NDPP.
Yes, that's correct, Chairperson. It would be consistent with this.
Yes, thank you. So it makes sense why then, on this issue that we have been wondering about as to why Advocate Chauke signed, he tells us in his affidavit, in the volume 1, LO00267, that it was his role to make sure that those documents were then forwarded to the NDPP, Advocate Jiba.
That is correct. It's in line with that. The important part being that he recommends the application, which a DPP would normally do, in whose jurisdiction the matter resides.
Yes.
Thank you, Chairperson.
Thank you. Thank you, Council. I think this is an appropriate time to take a lunch adjournment. It's 1:45. We will adjourn now and reconvene at 2:30.
Thanks, Madam Chair. We'll do that.
Yes, thank you. We'll adjourn for lunch until 2:30. Good afternoon, Council. You may proceed where you ended.
Good afternoon, Chairperson and your sisters and everybody else. Advocate Batohi, Madam Chair has referred you to when we adjourned, just before we adjourned for lunch recess, to LO1, paragraph 62.4. Paragraph 62.4, LO 00267, that's the page. We remember? Yes, 267. I'm going to ask you a very pertinent question regarding this sub-paragraph. And my question is, what Advocate Chauke is stating in this paragraph, has it to do with a prosecutorial decision or a prosecutorial? Has it to do with a prosecutorial decision?
Sorry, can you?
What,
I'm not clear about the question.
what Advocate Chauke states in this paragraph, has it to do with him taking a prosecutorial decision?
Is that
Is-
paragraph 62.4?
2.4.
In paragraph 62, Advocate Chauke sets out what he says his role was as team coordinator. And in 62.4, he says it included feedback and briefing to the team, including the submission of documentation not on the face of it, it's just submission of documentation. But if you submit documentation where you recommend prosecution or recommend the authorization of racketeering charges, that is taking a prosecutorial decision. And when Advocate Chauke signed the document we are referring to earlier, I don't have the reference now,
LO3 on page 665.
he was in fact taking a prosecutorial decision to recommend charges on racketeering to the national director.
Which goes to the root of paragraph 3.1.1
That's correct.
of the terms of reference.
That is correct. And there will be various other prosecutorial decisions that we will identify in the course of my testimony. Chairperson, if I may, we did check the signature of Advocate Chauke. It does not have an arrow in the ones we've checked.
My understanding, apart from the signature, was that 62.4 of LO 00267 might do the trick to answer why, instead of why Advocate Chauke signed instead of Advocate Noko.
Chairperson, I'm not sure what you mean by might do the trick.
Well,
My apologies.
The point was that what we asked you was why is it that the letter is signed by Advocate Noko?
Which letter, Chairperson?
You remember the letter is 26. Is it 265? Advocate Mutlamayana 266. 265. Just check that letter again. Is it 265?
LO. Let me just. 665, Madam Chair, if you are referring to that one, which
665.
which bears the names of Advocate Nokomashilo.
Yes. We asked you several questions about why Advocate Nokomashilo did not sign that letter herself. And you said that the signature looks like the signature of Advocate Chauke.
That's correct, Chairperson.
And I asked further, if that is the case, why didn't he sign PP? Because he is signing as the DPP KZN when he is not.
That is correct, Chairperson.
And then we went through the record, and a letter, or rather the affidavit of Advocate Chauke, in paragraph 62,
Yes, Chairperson.
he explains his role there as the coordinator of the team.
That is correct.
And he explains that 62.1, what he did, 62.2, what his role was,
Mhm.
62.3, exclusion, that he was not taking any prosecutorial decision,
Mhm.
whether to prosecute or not, and 62.4. He then explains that it was his responsibility to give a feedback and briefing on the team to Advocate Jiba, including the submissions of documents from the prosecution team to the NDPP,
Correct, Chairperson.
which seems, and I emphasize, which seems to support the proposition that he signed that letter following what Advocate Maema said.
That is correct, Chairperson, because it includes submission of documentation. So that is correct, Chairperson. But the same document, before we move off it, that's 665, doesn't support what he says in 62.3 as not excluding prosecutorial decisions, because recommending a racketeering charge is taking a prosecutorial decision.
Recommending a prosecutorial charge in
Racketeering in this instance.
in the letter
That is correct.
that he purportedly signed. He said that he took that decision. He recommended.
He does. Paragraph 2. I've perused the documents and recommend the application.
Let's unpack that. A recommendation is a recommendation. A decision, taking a decision per se, is a decision. Am I correct that the two concepts and the legal meaning thereof might differ? In other words, you recommend for someone to take a decision.
I understand, Chairperson. In the context of prosecutions, a DPP, when there is a case that involves racketeering, and the DPP then makes a recommendation to the national director, the DPP cannot take a decision to prosecute racketeering without, it's the national director's authority. But when a DPP recommends a prosecution, that DPP is taking a prosecutorial decision to recommend the prosecution. In that sense, you must be satisfied that the evidence supports your recommendation. And prosecutorial decisions, there's a range of decisions that prosecutors take in the course of a prosecution process that are prosecutorial decisions. And in this case, although it's a recommendation, it is a decision to recommend, a prosecutorial decision to recommend to the national director, and also saying that by saying I have perused the documents and recommend the application, you are satisfied that there's sufficient evidence to support the application. So that is the distinction, Chairperson.
My mind, let me clear my mind. My understanding is that following the request by Advocate Jiva to him, Advocate Chauke, to coordinate the team, his involvement was to that extent as a coordinator of the team. But we do know, when you look at that list that you referred us to earlier, of all those advocates from different jurisdictional areas, including Advocate Mayema from the Northwest, who was the head or the lead prosecution, the lead of the prosecution team. How then do we suggest that Advocate Chauke could take a prosecutorial decision when he is merely a coordinator?
Chairperson, Advocate Chauke says he's merely a coordinator, but the evidence does not bear that out. And if we refer, it's Chairperson said, and I hope I'm correct, Chairperson, you mentioned that Jiba asked him to coordinate. But if you look at Advocate Jiba's affidavit that she made, and I would ask the leader of the evidence to guide me in that regard, because I don't have it here. I think that will make it clear what Advocate Jiba's view was, that he was not merely a coordinator, that he was in fact the de facto DPP. The DPP in charge are the words that she uses in that affidavit. If I can be guided so that we can direct the panel to that particular aspect. And my point being, Chairperson, Advocate Jiba in that affidavit states that Advocate Chauke is the DPP in charge of this matter. And that's important to understand his role.
I'm not sure what it means. That may be open to different interpretations. When you say he is the advocate in charge, it could mean many things.
Chairperson, the evidence will guide what that can mean, and that will emerge from the evidence that will be placed before the panel.
The evidence of Advocate Musing, to the effect that Advocate Chauke was a coordinator, a mere coordinator, seemed to support his view that he was not involved as a decision maker, prosecutorially and otherwise.
I'm not sure where Advocate Mosing said that, but if that is what he said, he would definitely be supporting Advocate Chauke's case in that regard.
Yes, we'll look at the page, and if you look at Advocate Mosing's evidence, I'll pick up that page.
Sure.
Counsel, I'll pick up that page and refer you to it later. You may please proceed so long.
May I just come in here? From your evidence, and maybe also from the law, the Director of Public Prosecution does not have the power to institute action or criminal action relating to racketeering. The furthest, I want to understand exactly what your evidence is. Is it your evidence that when it comes to racketeering, the Director of Public Prosecutions can only go as far as to make a recommendation to the NDPP, and the power to then take the matter further lies with the NDPP? Is that a correct understanding? If not, please correct me.
That is a correct understanding.
Now, when you say that Advocate Chauke was exercising the prosecutorial power when he wrote, or rather, when he signed this letter that was addressed to the NDPP, the one that is at LO3, page 665. Maybe I should draw your attention to paragraph 2 of that letter in particular, which reads, I have perused the documents and recommend the application. Now, recommend in the sense and in the context of this letter, would you see it as a recommendation meeting the threshold that you are talking about, the threshold of the director making a recommendation to the NDPP, or what is your understanding?
So the first point would be, I didn't say it's a prosecutorial power. I said because that is not the power that the DPP has in respect of racketeering charges. I said that it was a prosecutorial decision that was taken by Advocate Chauke. And that's important because Advocate Chauke says if we go back to it, he did not take prosecutorial decisions. And in this case, the point is that making a decision that there is sufficient evidence in a matter to recommend a prosecution to the national director is a prosecutorial decision. And there are various other kinds of prosecutorial decisions that we take during a prosecution process.
So just to have a clear distinction for my own better understanding, the distinction between the prosecutorial power and the decision to make a recommendation. You would say the directors of public prosecutions do have the power to decide whether to prosecute or not to prosecute in respect of many other crimes, to the exclusion of racketeering. Is that correct?
That is absolutely correct.
That's fine. Thank you.
If I may, Counsel, just to follow up on that proposition that I made earlier, that the evidence that you submitted as annexures to your affidavit, the opinion of Advocate de Kock, if you look at the record, your annexure SB 3132, the internal memo to you from Advocate R.J. de Kock and team of 27 June 2019. It appears it's SB 3132, your annexure. If you look at page SB 3138, paragraph 12, it speaks to the delegation of powers, where Advocate de Kock and team suggests that there was a delegation and authorization issued to the prosecution team that was constituted by those people: Advocate Maema, Advocate Mtenjwa, Advocate Ntlakaza, Advocate Muleko, Advocate Mlochwa, Advocate Futani. And Advocate Chauke does not appear there. Then read paragraph 12 in conjunction with paragraph 13, where Advocate Musing is referred to by Advocate Kock. There it reads, Musing states that his understanding of Advocate Chauke's role was that he was open quote, merely to manage the team as they were mainly from his office, but would not be vested with any decision-making powers regarding prosecutorial decision. Now, if you read this part with the delegation paragraph, because I assume for Advocate Chauke to assume that role, the prosecutorial role in KZN, powers should have been delegated to him, as they did with the team of Advocate Maema. Am I correct?
Chairperson, that is correct. And the way that could have been done is if he was appointed acting DPP for KZN.
So I'll bring your attention to those amendments. That actually, I beg your pardon, I was drawing your attention to those amendments in the pages referring to what Advocate Kok says in the opinion referring to Advocate Musing and the delegation of the powers to the team, excluding Advocate Chauke.
Thank you, Chairperson. That's what Advocate Mosing says his understanding was of Advocate Chauke's role.
That said, what then do you make of this paragraph 12 and 13, where there's a delegation to a specific group, excluding Advocate Chauke, and the authorization to prosecute to this team, excluding Advocate Chauke, and then Advocate Musing, according to Advocate Kok and his team, state very clearly that Advocate Chauke merely managed the team, but was not vested with any decision to make a prosecutorial decision. What should we make of that?
Chairperson, paragraph 12 is clear that, and I don't have the evidence before me but clearly if we accept Advocate de Kock's report, and we have no reason not to, and his team, this team mentioned were issued with delegations and the necessary authority to prosecute a case because all of them were from outside KZN. So my understanding is that there is a provision in the Act that allows the National Director to issue delegations to prosecutors to prosecute in a jurisdiction outside where they are stationed. My understanding is, and I stand to be corrected, is that normally, well, I understand this. This is not what, well, let me be clear. Normally, if a prosecutor from one jurisdiction is and I speak about a prosecutor, not a DPP. A prosecutor from one jurisdiction prosecuting a matter in another jurisdiction is not uncommon. I won't say it happens, but when that happens, the prosecutor that goes to the receiving DPP, let's call it that DPP must issue the prosecutor delegation to prosecute in his or her jurisdiction. My understanding is that the NDPP has a similar power to issue delegations to prosecutors. So in this case, whether it was the DPP, but there's no evidence to suggest that, or the National Director, but that's understandable. They were issued with the delegation. So they were properly delegated, although the case is something else, but they were properly delegated to prosecute outside of the areas that they were stationed. With regard to paragraph 13, Advocate Mosing states his understanding was that this was Chauke's role to merely manage the team. But the evidence will suggest that that was not his role and that he was in fact the de facto DPP leading this team and in fact taking prosecutorial decisions.
If that were to be the case, it means you are presenting to us contradictory evidence.
In what sense, Chairperson?
In the sense that Musing says one thing and you say there's another evidence that presupposes that Advocate Chauke was vested with the prosecutorial decision making.
Chairperson, I am not presenting that evidence. The evidence is there in the docket. I'm leading the panel to evidence that demonstrates this in documents.
I may be wrong. Are you probably drawing an inference, making an inferential reasoning from the entire evidence, or there is a specific evidence to that effect?
Chairperson, I'd say there's specific evidence as well as an inference from all of the evidence when presented.
Inferential reasoning.
But there is specific evidence, and that's the evidence that I referred to is Advocate Jiba's statement, where she says that Advocate Chauke is the DPP in charge of this matter. And that shows he was the DPP in charge of this matter. We can try to find out what in charge means,
Yes.
but I think the common understanding is in charge is you are the one responsible for this prosecution. That's my understanding, Chair. But that is direct evidence from Advocate Chiba.
Yes. With regard to paragraph 12, I would imagine that if the delegation was supposed to have included Advocate Chauke, it would have been easy for Advocate Jiba to include his name, purely on the basis of the principle inclusio unius exclusio alterius. I'm trying to figure out the right English interpretation. The inclusion of one is the exclusion of the other. The inclusion of one is the exclusion of the other. Right?
Chairperson, I'm not sure that I follow your question. I want to answer it correctly.
When you make a list of things and then you include certain things and then you exclude the others, that principle kicks in. That you decide to include a group, and that inclusion means there's an intentional exclusion of the others. Am I wrong?
Chairperson, in this, you're not wrong on the principle. But Chairperson, in this regard, Advocate Chauke was appointed specifically as DPP in Gauteng. He could not exercise his powers as DPP in any other division.
No, I understand that. I understand your evidence around that.
Mhm.
What we are doing now, we are unpacking the facts that you are presenting before us to make a determination around those two bigger issues, whether he is fit and proper to hold office. Now, when we unpack that, it takes us to things like paragraph 12, whether he was indeed vested with the power to prosecute or not to prosecute. Now, what I'm saying is when the list is made where power is delegated, you would imagine that everybody to whom the power is to be delegated will be included in that list. And
Understood.
anybody who does not appear in the list means it was an intentional exclusion of that person. Because delegation is critical here. You don't just go to somebody's jurisdiction and exercise powers. You ought to have been delegated to do that.
Understood, Chairperson.
Yes. Now, paragraph 12 tells us subsequently delegations and authorizations were issued to the prosecution team that was constituted as follows. And it names those people, but excludes Advocate Chauke. And
That
that's
is
where
correct.
I am.
That is correct.
Thank you, Council.
Just once more. You know, I'm trying to settle this issue of jurisdiction, trying to distinguish between the Director of Public Prosecutions on the one hand and the prosecutors on the other hand. I'm struggling to do that, and I know you will assist me to understand that better. Is the understanding, maybe let me start off this way. let's talk about prosecutors just for a short while. The prosecutors get appointed by who? Is it the minister who appoints the prosecutors?
The minister appoints deputy directors of public prosecutions. That is the one level below a DPP. The level from DPP upwards are presidential appointments. The minister appoints deputy DPPs and chief prosecutors. They are on the same level. The one level below that, which are then your senior state advocates, it's not the minister, and it would be, I don't know whether it's the DG that appoints, but the ministerial appointment is only at the deputy DPP level.
Right. Do you know whether prosecutors are appointed for specific jurisdictions, or what is the position?
Yes, they are appointed in specific jurisdictions.
So for them to migrate to another jurisdiction, be it, I think temporarily, in the context of this matter, would that require, whose authority would be required to authorize that temporary operation from a different jurisdiction from the one which the prosecutor would have been appointed for?
If that scenario happens, then what would normally happen is the two DPPs would speak and they would agree that a prosecutor from one division will go to the other division to assist or to prosecute. In that event, the DPP of the receiving DPP will have to issue a delegation there that gives that prosecutor the power to conduct a prosecution in his or her jurisdiction.
And finally, would the NDPP have the power to delegate the director of public prosecutions?
Chairperson, I seem to think there's a provision in the Act that allows for that. Perhaps the evidence leader can check and correct that, but I could be mistaken. I have not done that in my term. I can't recall having done that. But I think there is a power. We can correct that.
Yeah. Would you like the evidence leader to give you the relevant?
I would appreciate that, Chairperson.
So that you can refer. I wouldn't want him to be giving evidence.
I would appreciate that, Chairperson.
That is the NPA Act.
That is correct, Chairperson.
You don't have it with you there.
I do have it, but I need to be referred to the section, if there is one, that in fact confers such a power to the NDPP. Otherwise, I'd need to go through it to check if it is there.
Yeah. So what I'm trying to avoid, you are saying it would rather be done that he then give information on the relevant enabling provision.
If there was one, if they direct me to it, then I can testify to that effect, Chairperson, whatever it might be.
Chair, through you, may he just do that, please.
Yes, Council, are you in a position now to assist with the relevant provision of the Act so that Advocate Batoyi can reflect on that? If not, your colleagues can flag that aspect, and then later, when they are ready, including Advocate Haile Adebeg there, then we can then revisit this aspect. Is it possible to do that?
It's not possible.
Unless if you are ready now.
No, I'm not ready now to refer her to the specific section in the Act.
In that event, I beg your pardon.
Thanks, Madam Chair. The questions that have been posed to you, Advocate Batohi, brings into sharp focus in our quest to unpack the issues here. brings into sharp focus as to what exactly is a prosecutor. And that's where I want us to start. A prosecutor is defined in the Act. Let's go to the Act and get a definition of a prosecutor before we get to your concern.
In the definition section.
Definition section, yes.
Just may I just come in here, please? Are you on your way to enabling the witness to settle this issue that I have about the jurisdictional point, the distinction between directors of public prosecutions and the prosecutions? Is it
Indeed.
the route there?
I'm on my route to there, Madam Ramachaka.
Okay, thank you. Then you can proceed.
With the help of my colleagues about the section, specific section, but I'm on my route to that because it is important, Advocate Patohi, that we should understand what is a prosecutor. Is a DPP a prosecutor? How
Not
does
in
it?
terms of the definition in the Act.
Just a minute. Hang on. I'm sorry to interpose. The unpacking of these issues, as I indicated, brings into focus what is a prosecutor? How does a prosecutor, how do you compare a prosecutor with an NDPP? What is the role of a prosecutor vis-a-vis a DPP? Let's go to the definition section then, and kindly read the definition section of what a prosecutor means.
So a prosecutor in section 5.
No,
No, it's
before.
not so. It's in the
bef-
definition section.
Yes,
sorry.
go to the first.
Chapter
Let's
1,
start.
section
Yes.
1. Prosecutor means a prosecutor referred to in section 16.1. Then
Let-
if we,
Let's go to 16.1 and hear who a prosecutor is and what is a prosecutor.
section 16.1 states, prosecution shall be appointed on the recommendation of the national director or a member of the prosecuting authority designated for that purpose by the national director, subject to the laws governing the public service. Prosecutors may be appointed to the office of the national director. Two, prosecutors may be appointed to A, office of the national director, B, offices established by section 6.1, and that's the DPP offices, C, investigating directorates, and D, lower courts in the Republic. Paragraph 16.3 states the minister may from time to time, in consultation with the national director and after consultation with the directors, prescribe the legal qualifications for the appointment of a person as a prosecutor in a lower court. 4, insofar as laws governing the public service pertaining to deputy directors and prosecutors may be inconsistent with this act, the provisions of this act shall apply. Having said that, I want to correct something that I said earlier on when asked about the appointment of prosecutors, and I mentioned the DG. The DG doesn't have a role in appointing prosecutors. The HR functions are with the minister, but the minister can delegate those functions. So I just want to clarify that, and I'm not sure where it's delegated to, but we can check that in terms of who appoints below the level of DDPP.
Go to section 20 of the NPA Act. 20 subsection 5. Read it because it deals with the competencies of a prosecutor.
It reads, any prosecutor shall be competent to exercise any of the powers referred to in subsection 1 to the extent that he or she has been authorized thereto in writing by the national director or by a person designated by the national director. And if we go to subsection
6.
1, sorry.
You want to go to subsection 1?
No, just to explain subsection 5, because it refers to the powers in subsection 1. And those are the powers that are listed there to institute or conduct criminal proceedings on behalf of the state, to carry out the necessary functions incidental thereto. I'm not quoting verbatim, and to discontinue criminal proceedings.
Thank you. To answer Madam Ramahaka's concern and question, I'm informed by my colleagues that there is no provision in the Act, in the NPA Act, where a National Director of Public Prosecutions can delegate a DPP to another jurisdiction. It's not provided for.
Is that the case? Do you confirm what the evidence leader is placing on record?
Chairperson, if I could have a look later, and then I'd be happy to confirm that at a later stage. I will discuss with my team, and I'd like to check. I'm under oath, and I want to make sure that that's the correct information. I have no reason to doubt them, but I want to make sure.
Yes, Madam, I think it is proper to take that posture. Advocate Mutlamunyane, you may be entering the zone of argument, legal argument, with the position that you've just made, because the very evidence you are talking about is the evidence that your client, or rather Advocate Batoyi, has presented to us. The DCOC documents are part of her evidence. And it is that evidence in paragraphs 12 and 13, whether it is in line with the law or not, the fact of the matter is that it is the evidence that Advocate Batoyi presented to us. We will deal with the veracity of that evidence probably later if a need arises, remembering that we are on the fact-finding process. So I suggest that we don't get into legal argument. Let us concentrate on the facts.
Chairperson, may I clarify something?
I beg your pardon,
May
Madam.
I clarify?
Please wait a minute. Let Counsel confer with Advocate Mutlamunyane.
So the only delegation in which we give delegations to all the other cases of part of the prosecution to all the family. But yeah, I'm not sure. But talk about I'm not so sure about all the other cases, all delegations.
We proceed with the question.
We are having different conferences in this space. I think we will have time to revisit these topics at a later stage, because I'm not sure what the right answer is, but we are guided by the affidavit of Advocate Batoyi together with her annexures. We are working on that evidence as we are clarifying few aspects by asking her questions.
Chairperson, if I may clarify something on
Yes,
that aspect, because
yes.
it is my affidavit, and I'm listening very carefully to what you're saying. I want to explain that my affidavit, firstly, was drawn up at very short notice. We were under tight timelines. There may be things that are in here. There may be things that are not in here that should have been here. But of course, we tried to be as precise as possible in the very short time space that we had. To explain that the annexures to my affidavit are not necessarily my evidence. I want to explain what I mean by that. I explain the process that in my affidavit, I explain the process leading up to the referral. And in that process, if you bear with me for a moment, Chairperson. I'm just trying to find my affidavit. I have it right in front of me. Yeah. In the process, which is on page 69 of my affidavit, I have set out what the steps I took leading up to the referral. And I mentioned the various legal opinions that I received. So that is not, it's attached to my affidavit as opinions that I received. And Advocate de Kock's memorandum is one of the is a report that I received from the team. And because I refer to it in my affidavit, I have attached all these documents for ease of reference for the panel. There may be parts of it that I may not agree with. There may be parts of the annexes that I agree with, but I wanted to clarify that. Thank you, Chairperson.
Well, of course, it is so that these documents formed part of the documents as a result of which you formed a prima facie view when you referred the matter to the president.
Chairperson, let me explain that because it's important for the panel to understand. I received these opinions. When I received Advocate Nalane's opinion, which is referred to in this process and is an attachment, I then sent that document, this is all set out in my affidavit, to Advocate Chauke and asked him to respond to that. He then submitted Advocate Maineche's report, which is also attached to this. As a result of those two legal opinions, it was clear that there were gaps in evidence. And I emphasize those are opinions. There were gaps. And so I then asked Dr. Broughton in my office to get all the evidence and then to prepare an opinion to me. He initially prepared one opinion, which I gave him just a week to do it, and it was too short notice. He came back to me and said he needed more time because he needed to look at a whole range of documents. He then provided me with a supplementary opinion. But that supplementary opinion, in my view, is almost like a forensic analysis of the evidence, because together with his opinion, he provided me a bundle of evidence. And my decision to recommend to the president was based primarily on the evidence that was provided to me, attached or forwarded as annexures to Dr. Broughton's opinion. So I want to be clear about that because the others were opinions that I considered, but when I made the decision, I looked at the documents, many of which we are presenting now. Some of that may not be presented, but I will speak to council about the entire bundle being handed in as evidence because that is what I based my decision on, looking at actual documents, statements, etc. I hope I've clarified, Chairperson.
Yes, and I think you repeat what I'm saying, but in different words. In other words, when you made a referral to the president, these very documents were part of the initial bundle
That is correct, Chairperson.
in terms of which the president had to consider your request.
That is correct, Chairperson.
And these documents assisted you, all of them, assisted you in formulating a view whether to refer or not to refer.
They certainly assisted me, Chairperson, but I do want to emphasize that I looked at the underlying evidence, and that was the main. I came to a conclusion based on my own analysis of the underlying evidence together with the opinions.
You may proceed, Council.
Thank you, Madam Chair.
My apologies.
I heard you earlier. earlier saying VGM, and
My apologies, Chairperson.
I
Maybe
don't know what is VGM.
It stands for the Victoria and Griffiths Mtenge Building, which is the name of the NPA head office in Pretoria. VGM is Victoria and Griffiths Mtenge. That's the short form acronym for the name of the building, Chairperson.
Thank you.
Thank you, Madam Chair. Perhaps it is an opportune moment, Advocate Patohi, to, whilst unpacking issues, explain to the ordinary person what racketeering is. So that it should be clear why prosecutors acted in the manner in which they did. What is racketeering? How
So,
Pick, cancelled. Please pack it there. I just want to finalize a niggling issue concerning the role or the alleged role of Advocate Chauke in KZN. Assuming for now that Advocate Chauke did participate in the prosecutorial decision making, in terms of which he would have then entered the jurisdictional area of another DPP, something that the law prevents, unless certain prerequisites are adhered to. Am I right?
indeed, Madam Chair?
Would you please deal with that aspect as to what is it that ought to have been done if we assume that indeed Advocate Chauke, as Advocate Batwe is saying, did participate in the prosecutorial decision making. This is just a proposition that need not be correct, but it's on the assumption that what he says is correct. Then what ought to have happened as a requisite or a prerequisite for doing that, leaving Gauteng, South Gauteng division, going to KZN division to do that? What does the Act requires?
Madam Chair, that can be explained by Advocate Patohi, and maybe the law provides for that. But I was of the view that because we are dealing with very serious offenses, or an offense called racketeering, I should start there so that racketeering can be explained as to what it is, and the seriousness thereof, before we could get into the issue of whether another DPP can get into the area of one DPP can get into the jurisdiction of another DPP.
In other words, I ran ahead of you.
Indeed, Madam Chair.
Thank you.
You preempted me.
Along those lines.
As it pleases, Madam Chair. Advocate Patohi, may you explain what a racketeering offense is? It's a very complex offense. What does it entail? Bearing in mind what was earlier read into the record as far as the law is concerned on racketeering.
so I suppose you don't want me to give you the legal definition, in which case we have to go to the Prevention of Organized Crime Act and deal with the legal definitions. You just want me to explain in layperson's terms what racketeering means.
Start with the legal definition and you can go to the layman's term.
We will need to go to the Prevention of Organized Crime Act then, if I could. I don't have that in front of me. If I can be directed to the Prevention of Organized Crime Act. if we want the actual provisions of the law.
We'll make a plan that you get a copy.
We can deal with that later.
Yeah.
Thank you, Chair.
For now, explain it in layman's terms. What is it?
Thank you. So racketeering is basically a charge where the prosecution needs to prove that there is an enterprise. That means there's a group of people that are associated, in fact, or it's a particular entity that can be identified, and that they are engaged in a pattern of racketeering activity. And it's not very easy to describe it in layperson's terms, but it means that this group has together engaged in various types of criminal activities, are the predicate offenses, and that they worked together in order to achieve the objectives of that group, which is normally a criminal objective. But various people in this group have various roles. For example, you could be a manager, you could participate in the enterprise. And so there are various parts of the act that criminalize various activities. And so in a nutshell, it's a group of people working together to achieve a criminal outcome, and engaging in various types of criminal activities.
I think, Counsel, I see Advocate Haley's junior counsel. You can come closer, madam, and assist Advocate Batoy with documentation that she might need.
Thank you. I have the prevention of organized crime, but is it okay if I went without, I don't know if the panel has the act in front of them. Should I proceed, Chairperson? I'm guided by you.
We do have our act somewhere in our bundles, but we may proceed and it's subject to what counsel says. If it is necessary to read verbatim what the act says.
This brought me to the first page of the act, and I need to go through it so that I can get to, I think it's section 2 that deals with the offenses. Okay.
Counsel, is it what you want the witness to do? To go through section 2 of the POCA?
I'm going. Chairperson, sorry.
Maybe for current purposes, we may revisit it at a later stage. If the need arises, just read section 2 in brackets 4 into the record.
Sure. Section 2, paragraph 4. Well, it's chapter 2. Section 2 deals with the offenses. 2.1, I'm trying to get to 2.4. It's 2.4. 2.4 deals with the authority of the national director. Says a person shall only be charged with committing an offense contemplated in subsection 1 if a prosecution is authorized in writing by the national director. That's section 2.4.
Leave it at that for now. We can come back to it. But in your bundle, Advocate Batohi, Advocate Dikog and his team deal with racketeering offenses. They explain it at great length as to what they entail.
That's correct.
Let's park it for now. Let's leave it at that for now and continue with your evidence. But they deal with it on page 215 of SB3 under subparagraph E. They deal in extenso with what racketeering is all about.
Yes, that's correct. From paragraph 212.
I want to
Well,
refer you to
I think that, sorry, before we move on, paragraph 212 deals with the particular cases. I'm not sure whether it deals broadly with what racketeering is about, but I'm sure.
yeah, let's pack it for now. It's all right. It's okay. Whilst you are dealing with prosecutorial decisions as to what exactly constitute prosecutorial decisions and the role of Advocate Chauke, may I draw your attention to LO 3, page LO 00782, and may I mention, Madam Chair and your sisters, that the document I referred the witness to is a document of dates of meetings, page 00782, LO3 bundle. This is a document prepared by, I should believe, by Advocate Chauke, in which he was indicating his role and the meetings he had with IPID, SAPS, and the judiciary until August 2012. Are you there, Advocate Batohi?
I'm getting there. Just 7, 8.
782, Madam Chair. Now, it impacts on the TOR paragraphs 3, 3.1, 3.1.1, 3.1.1.1 of the TOR. Now, please read the document into the record.
So, Chairperson, if
To read the entire document, which is quite a long, from 782, date of meetings with the prosecuting team of Katumena and briefing with acting NDDP, as well as meetings with IPID, SAPS, and judiciary until August 2012.
Let me direct her attention to specific dates without reading the whole document. Start with the 3rd May. Read the heading and go to 3 May 2012 at 1300 hours.
yes, if I may, Chairperson, this appears to be an annexure, and Council will guide me. At 781 is an email from Advocate Chauke to the team, to various persons. And it says, "Good day to all. Here with dates of meetings and briefings I have recorded in my activities diary. I hope it meets with all that is required from me to extend that I was involved in the Cato matter." And then it appears that that is attached to that affidavit, to that email.
Yes, you're correct. You're correct. Proceed then to the email was directed to the Katomana team. Is that correct?
Yes, it appears so.
Yes. Now start with the 3rd of May.
Amongst others, the acting NDPP is also copied in there. It's addressed to her as well, and others. I should say it also appears that the DPP of KZN is also CC'd at it's Moipone Noko. I see her name there as well. And this is the date of this email is 30 September 2015.
May.
Should I read that?
Start with the heading.
The heading is dates of meetings with the prosecution team of Cato Manor and briefings with acting NDPP, as well as meetings with IPID, SAPS, and the judiciary until August 2012.
Read the entry of 3 May.
3rd May 2012, it's the first entry at 1300 hours. Meeting with Advocate Jiba, re Cato Manor matter, arranged for briefing for 18 May 2012 at 800 hours.
Read the second one, 22 May.
22 May at 2020, meeting with Brigadier Mokwena, in brackets Hawks, Mr. Angus, IPID, Maema, Ntlakaza, Moleko, Mlochwa, and Fuchane, Matenjwa in court.
Go to the 24th.
At 8 a.m., briefing with acting NDPP at Pretoria with the whole prosecution team, Cato Manor, Advocate Matenjwa doing the briefing, category of dockets, sub 1, conspiracy to kill members of Kwa Maputo Taxi Association, 2, conspiracy to kill ATM bombings syndicate, 3, conspiracy to kill criminal gangs, security for the prosecution team, SAPS National Office, delegations, protection, Part 8 of Prosecution Manual and Section 17 of Inquest Act 58 of 1959 also discussed.
Go to the next one, the 4th, 29 May 2012.
At 1500, Cape Town, briefing with Minister of Justice and acting NDPP, need to prepare the draft indictment and finalize the allocation of a judge to preside over the matter. Need to speak to South Gauteng DJP or JP of Gauteng.
Go to the 11th.
At 13,
June.
11 June at 1300 hours, meeting with Mr. Björkman of IPID and Matenjwa.
Go to the 18th June.
18 June at 2012 at 1200 hours, meeting in Durban Magistrates Court with Cato Manor prosecution team.
Go to the next page, 784, 00784.
18 June at 1400 hours, meeting with acting NDPP and AJP, that's acting JP of KZN, in Pietermaritzburg regarding Cato Manor matter.
Go to the 20th June, the second 20th June.
At 1600 hours, Durban High Court urgent application for release of arrested Cato Manor members, application dismissed and referred to regional court.
Go to the next page. Go to the entry of the 6th.
6th of August 2012, meeting with Cato Manor team, editing the indictment and memo to acting NDPP.
And we say, Madam Chair, that this has an impact on the TOR, specifically paragraph 3.1.1.3.1.1.1.
Chairperson, this, in addition to other evidence, will show that Advocate Chauke was not just a coordinator. He was deeply immersed in this particular prosecution.
Go to the 8th August.
8th of August 2012, 1800, Cato Manor indictment preparation and arranged to brief acting NDPP.
Proceed. The second 8th August.
At 1100 hours, VGM, that's the NPA head office, briefing session with the acting NDPP Jiba, re Cato Manor and certificate of centralization.
Go to the 9th.
We will explain that in due course, the certificate of centralization. The 9th, Durban at 1500, 9th of August 2012, Durban KZN briefing with Moipone Noko, acting DPP KZN at 1800 hours.
Go to the 10th August. There is no time specified there.
Meeting with KZN JP and acting DPP and handed draft indictment to him, memo to be sent by acting DPP on Monday, 13 August 2012.
August, the second one.
Meeting with acting NDPP rebriefing regarding misconduct hearing and prosecution policy in Cato Manor matters.
Go to the next page. 786. 24 August.
Durban Regional Court appearance of General Boyson and others re Cato Manor matter.
That is all, Madam Chair, as far as that is concerned.
Just a minute. And these to which term are they relevant?
I indicated
You read the first batch and now, or is it just one continuous list? Okay.
it's one continuous list, Madam Ramakaha.
Okay. Thank you.
Advocate, if I may ask, all these entries that you were referring us to from LO0078 to LO00786, and you said they tied with the terms of reference at 3.1.1.1.
Indeed, that is so.
We've had evidence, well, at least corroborated by Advocate, is it Musia or whoever? Mosing, that Advocate Chauke played a role of a liaison between the prosecutorial team in the Cato Manor and the acting NDPP. Now, these entries, these meetings, these briefings that are mentioned here, do they in any way result into Advocate Chauke taking a role of a prosecutor or taking prosecutorial decisions? Or this is just a licensed person giving regular briefings on behalf? Because in other instances, he says he's with the whole team or he's alone or whatever, but can we clarify that? The witness clarify that.
Maybe I should not be seen to be testifying from the bar. The best way is to ask the witness to clarify that. To the extent to which you can, Advocate Patohi, can you clarify the role that Advocate Chauke is indicating in this document?
Well, in this document, as it purports to be, dates of meetings and briefings. And there's no indication in this documentation that there's any prosecutorial decisions that are taken. It's just a list of meetings and briefings. There is indication that Advocate Chauke is involved in activities that go beyond mere coordination. For example, if you look at the 6th of August meeting with the team, editing, that's not just a coordination function, that's getting involved in the memo would be a prosecution memo which would contain evidence in the matter. The 8th of August at 8 a.m., indictment preparation. Likewise, that's not simply a coordination function. And we'll deal with the centralization certificate. There is evidence that will be led about that shortly. The evidence leader will decide when to take me there. But certainly, well, I should change what I said earlier. I said none of them refer to taking prosecutorial decisions. I should change that. This particular one, that is the signing of a certificate of centralization. Let me explain first, perhaps, Chairperson, what a centralization certificate is. I had explained earlier, but I'll refresh our memories. This is where there are various offences committed in different parts of the country, and the national director, upon application by the two, well, depends, if let's assume it's in two provinces, the DPPs of the two provinces would apply to the national director for a centralization of these matters into one area, for better management of the case. The taking of a decision on whether to centralize or not is a prosecutorial decision that the DPP will take in consultation with the others in terms of where the case should be heard, which jurisdiction, etc. Those all relate to taking prosecutorial decisions, and a decision to apply for a centralization certificate from the national director would normally be made by the DPP who has jurisdiction over the matter. So I leave it at that for now. That is the way the centralization process works.
Does the NDPP get involved in the centralization process?
The NDPP authorized this, the central.
Authorizes.
That's correct.
But maybe as a follow-up, because these notes are very cryptic. For example, where you talk about a certificate of centralization, we are not sure whether it was what was the purpose, what was happening with the certificate of centralization. Was Advocate Chauke, had he approached the acting NDPP to apply for a certificate of centralization, or they were just discussing the centralization? Well, it is so cryptic that one cannot make head or tail of exactly what was happening here.
Yes, Chairperson, these are Advocate Chauke's notes, but there will be evidence that he did indeed apply for centralization.
Thank you.
Thank you, Madam Baloimere. Maybe we should hasten at this moment to go to Dr. Broughton's supplementary affidavit, which is L01. I beg your pardon, it's not an affidavit, it's an opinion. It's a slip of the mind. I said affidavit, Dr. Broughton's affidavit.
It's his opinion, yes.
Yes. It's in L01. Direct your attention to page 188, L00188. Madam Chair, you've located the page is L00188 in bundle 1. L01 to be specific, L01. I direct your attention, Advocate Batohi, to paragraph 55. May you read paragraph 55 into the record. You may not read the whole of it, but read the first sentence and we'll take it from there.
Okay, thank you, Council. You'll tell me when to stop.
Yeah, I'll tell you when to stop.
Sure.
Read paragraph 55.
It is further to be noted that Advocate Chauke made an entry in Annexure J, and Chairperson, this would be Annexure J to his opinion, that on 6 August 2012, he had a meeting with the Cato Manor team, editing the indictment and memo to acting NDPP, in quotes.
Wait a minute, just allow me to interpose there. If you refer back to LO3 bundle, LO 00786,
Yes, that's the...
where Advocate Chauke held meetings with various authorities. Is that what, on the entry of 6 August, it says editing the indictment. Is that what Dr. Broughton was referring to?
Yes, that appears to be the same meeting that is being referred to in this paragraph.
Yes, proceed to read.
Advocate Chauke thus records that he is involved in the preparation of the memorandum and the application for racketeering authorizations. Annex E, that's to his opinion. In the very next entry dated 8 August 2012 at 800 hours, Advocate Chauke stated as follows: Cato Manor indictment preparation and arranging for brief acting NDPP. Again, Advocate Chauke was recording his involvement with the preparation of the application for racketeering authorizations, Annex E in brackets, to be submitted to Advocate Jiba. Advocate Chauke then records that on 8 August 2012 at 1100 hours at VGM, he had a briefing session with the acting NDPP, Jiba, regarding Cato Manor and certificate of centralization. Advocate Noko was not involved with that, even though she was supposed to be the DPP responsible for the Boyson prosecution. However, Advocate Chauke then made the entry that on 9 August 2012, at 1800 hours in Durban, he had a briefing with Moipone Noko, acting DPP KZN. This is the first time that Advocate Noko features in or is mentioned in the attachment of Annex J. Advocate Chauke does not state what the nature of this briefing with Advocate Noko was. There is no mention that he provided the Boyson Cato Manor case dockets to her. The very next entry records that on 10 August 2012, Advocate Chauke had open quotes, meeting with KZN JP, an acting DPP, and handed draft indictment to him. Memo to be sent by acting DPP on Monday, 13 August 2012. Advocate Chauke does not state what memorandum was to be sent by Advocate Noko on 13 August 2012. It is to be observed also that Advocate Chauke records that he handed the draft indictment to him, which must be referring to the Judge President of the KZN division. Should I continue?
Continue.
The impression is created that Advocate Chauke was in charge of the Boyson prosecution and Advocate Noko was simply on the periphery to give a veneer of legitimacy to the process that it de jure did not have. The question arises why Advocate Chauke was involved in this process of filing the indictment with the KZN High Court. Surely the Boyson prosecution team, in terms of their special delegations, were required to be reporting to Advocate Noko, through whom the indictment was supposed to be filed. Should I continue, Counsel? Although we do not know ex facie the attachment, what the memorandum was to be submitted by Advocate Noko relating to the case, it speaks volumes, like with his affidavit to the State Capture Commission, Advocate B, that Advocate Chauke is silent in the attachment as to the events of 15 August 2012 with regard to the signing of the covering letter with the recommendation of the application for racketeering authorizations, Annexure E.
You may hold it there. This then takes us to the affidavit of Advocate Noko.
Advocate?
Noko,
Okay.
it is contained in bundle LO1 on page LO00241.
Sorry, LO24. Sorry, can you repeat that, Council?
241. May I proceed, Madam Chair? Thank you. It makes interesting reading. May you read it into the record and explain under what circumstances. This is an affidavit by Advocate Noko. May you read it into the record, Advocate Batohi?
It's an affidavit by Advocate Noko. It appears also in the Silverton CAS number, which is unclear. Paragraph 1, I am the Director of Public Prosecution in KwaZulu-Natal, Division of the High Court of South Africa. My ID number is, I won't mention it for current purposes, Chairperson, and residing at Durban with my office at 301 Church Street, Pietermaritzburg, High Court, Pietermaritzburg. I won't mention her cell phone numbers, Chairperson, that are included here. Paragraph 2, my mandate as the Director of Public Prosecutions in KwaZulu-Natal in terms of the NPA Act 32 of 1998 and the Constitution of the Republic of South Africa 108 of 1996. Paragraph 3, since the Cato Manor case came into being, I have not been directly overseeing it as the DPP. I have not been directly overseeing it as the DPP until around March or April 2014, when the National Director of Public Prosecutions, Mr. Nkolisi Nqasana, instructed me to start directly overseeing the case. This instruction was given during a meeting when the prosecution team was briefing him on the developments of the case. Before this instruction, the Director of Public Prosecution, South Gauteng Division, Johannesburg, Advocate Andrew Chauke, was directly overseeing the case, and he also supervised the prosecution team, and they also reported directly to him as far as the case is concerned. 4, the prosecution team was established before my involvement and the following advocates are part of the team: Advocate Maema, Advocate Matenjwa, Advocate Mslakaza, Advocate Moleko, Advocate Mnochwa, Advocate Fushane. I'm just using the surnames. Paragraph 5, during August 2012, while I was the acting Director of Public Prosecutions, KwaZulu-Natal, I was requested by Advocate Chauke, DPP South Gauteng, to sign a covering letter to a prosecution memorandum intended for the NPA head office. I signed this covering letter as procedure, being the acting DPP where the matter is pending, but not directly overseeing the case. DPP South Gauteng was. The matter is still pending in the KwaZulu-Natal High Court in Durban and is sub judice. The matter appeared in this High Court again on 30 March 2015 and further postponed to later during this year. Paragraph 7, that is all I want to say, and then the oath follows.
Next page. She signs it.
Yes, I beg your pardon.
What date was it?
Well, it appears to be her signature. I'm not sure. I can't recognize her signature.
No, I mean the date. Date there
The
appears.
date is the 31st of March 2015.
Yeah, she makes mention in the affidavit, specifically in paragraph 3 of the National Director of Public Prosecutions, Mr. Nkkolisi Nqasana. To interpose, maybe we should find out as to when Mr. Nqasana took office. to clarify this?
I don't have the precise date when he took office.
We are having it here. It's written to us here. I'm being given a document which says Mr. Advocate Nkoli Singkasana was appointed with effect from the 1st October 2013 and he vacated office on 14 May 2015. I'm sure this will not be in dispute.
I have no reason to doubt the correctness of that.
Now, what you have read here is given on oath by Advocate Noko pertains to paragraphs 3, 3.1, 3.1.1 of the terms of reference. Not so?
That's correct.
Madam Chair, we will now proceed to centralizations. It will become clearer as to what exactly a centralization is. Go to page, let me see, 781.
Council, just give me a second, please. Advocate Mutlamunyane, it's 4:05 on that watch in front of me. Are you going to be long on this aspect? Or would you like, if it's going to be long, it will probably be better to defer it until tomorrow. But if it is a matter that can be disposed of quickly, then we can deal with it.
It cannot be easily disposed of as quickly as we would have loved. Maybe it's appropriate to leave it and roll the matter over to tomorrow morning.
We consider then that this is an appropriate time to adjourn. You'll take it from here with regard to Advocate Ngasana's assumption of office. And we will begin at 9 o'clock tomorrow morning. If council can be here to meet us for 5 minutes, around 8:45, we so propose. In that event, Advocate Batoi, we will take an adjournment until tomorrow morning at 9 o'clock. We adjourn.